Distinguished guests, ladies and gentlemen, good afternoon to you all. It is my great pleasure to join together with you through the webinar conference to attend the 2022 Annual Conference of Asian Domain Name Dispute Resolution Center, ADNDRC, to celebrate the 20th anniversary of the organization. We are very pleased to have with us representatives from the registries, registrars, experts of domain name dispute resolution and IPR dispute resolution, so that we can discuss the future development of DNDR dispute resolution against the background of digital economic transformation. On behalf of SciTech and ADNDRC, allow me to extend our warmest welcome and heartfelt gratitude to all of the guests joining us online and in person. Firstly, I'd like to invite Mr. Wang Chengjie, Vice Secretary General, Vice Director General and Secretary General of SciTech, President of ADNDRC, to make an opening remark. Mr. Wang has more than 30 years of experience in resolution of disputes. And he is also one of the main promoters of the establishment of ADNDRC. He's now the rotatory president of the organization, leading us to embark on the new journey of development. Distinguished guests, ladies and gentlemen, good afternoon to you all. It is my great pleasure to represent SciTech and ADNDRC to welcome all of the guests joining us online. And we have guests from both home and abroad. Thank you for attending the 2022 ADNDRC Annual Conference. Firstly, allow me to extend my heartfelt appreciation to ICANN, the Internet Corporation for Assigned Names and Numbers, CNNIC, CINIC, China Internet Network Information Center, and CAICT, China Institute of Information and Communication, for their generous support of today's event. Allow me to also thank the well-known and prestigious experts, scholars, judges, representatives of the registrars and registries, as well as service organizations of dispute resolution for the upcoming presentation, sharing with us their insights. I would also like to thank the team from the 4 offices, Beijing, Hong Kong, Seoul, and Kuala Lumpur of ADNDRC for their conscientious effort to support ADNDRC. In retrospect of the past 2 decades of development of the organization, we have been embracing an important historical juncture, which has milestone significance of ADNDRC. It has went through 2 decades of development of dispute resolution for domain names, and has been promoting the protection of IPR and domain name rights in the digital economic era. 20 years ago, in 2002, to respond to the demand of dispute resolution brought up by internet economic growth, we established, together with SciTech and Hong Kong International Arbitration Center, the organization called ADNDRC. ADNDRC is also one of the 6 accredited and authorized dispute resolution organizations in the world by ICANN. It is also the first dispute resolution service provider of generic top-level domain in Asia. It has been a vanguard and pioneer in leading the Asian domain dispute resolution mechanism and efforts. Later, with the accession of IDRC of Korea and AIAC, Asian International Arbitration Center, in 2006 and 2009, the center has 4 offices in the world: Beijing, Hong Kong, Kuala Lumpur, and Seoul, and has a radiative impact of serving parties in Asia. It has, in particular, 3 bodies or panels under the framework of its organization, namely Panels in Action Committee, Business Development Committee, Standards and Practice Committee. In its 2 decades of development, it has received a total of thousands of cases in domain name disputes with parties from 50 countries and regions, and has provided multilingual, multi-domain, and multi-jurisdiction and multiple services to resolve the disputes around domain names for its parties, safeguarding the legitimate rights and interests of businesses, and has been playing a crucial role in pushing forward the healthy and sustainable development of the internet economy. The Center has attached great importance to the selection and training of experts. The expert panel functions as an important referee mechanism. This is one of the advantages of dispute resolution. We have a total of 135 registered experts in the organization, mobilizing experts from various sectors, well-known scholars and experts, attorneys, judges. All of them are quite experienced in dispute resolution and legal practices. And we have also been organizing regular seminars, webinar conferences, trainings for the experts, and have been very stringent and robust in the selection of the expert panel. In April this year, the Center also summarized our experience and best practices and formulated the guideline of decision writing so as to provide support and reference for judges and experts to write decisions and rules of the dispute resolution. So we have been contributing to the practice of domain name dispute resolution for the past 2 decades. Now we are faced with the new challenges brought up by the digital economic era. According to the latest China Digital Economic Development Report 2022 released by China Information and Communication Research Institute, the scale of China's digital economy reached 45.5 trillion yuan in 2021, a nominal increase of 16.2% over the previous year. 3.4% higher than the growth rate of GDP in the same period, accounting for 39.8% of the GDP. So we have been seeing and witnessing the emergence and the thriving of a digital economy. International trade has been expanded from a physical space to the digital arena, promoting online and offline production and consumption. And also the B2B, B2C e-commerce has enjoyed a very booming development. Especially in the recent years, we've seen very fast speeding up of the digital economy, and people's behavior has been very much landed at those digital platforms. Therefore, the legal relations of various parties, including the dispute resolution, is actually happening more and more on the digital platform. So I think all these impose new challenges for the way that we provide services to dispute resolution. To respond to that, I like to offer some of my personal proposal and perspectives. Number one, the combination of digital economy and dispute resolution has become a new trend. We've also noticed that the internet technology has been very much adopted in the case filing, hearing, holding a court session, the exchange of documents for the conventional way of arbitration and dispute resolution. So we need to also pursue innovation so that we can respond to such change of the demand. Therefore, SciTech, including ADNDRC, have been promoting the construction and adoption of digital smart platforms to support the online case filing system and smart hearing and court proceeding system. I believe that this online platform did provide a lot of convenience for the parties and arbitrators to complete the procedures of a dispute resolution so as to safeguard people's rights and interests. The online document exchange platform is another typical case illustrating the efforts of promoting informatization and digitalization of the proceedings. We are also building some of the so-called highway tracks for the parties, for the arbitration tribunals, and for arbitration institutions, so that we will be able to support the intelligent arbitration services for Chinese and foreign parties. In addition, we've also been cooperating, the SciTech has been cooperating with APEC ODR mechanism, so that we can help to facilitate the cross-border B2B small value commercial dispute resolution that is supported with this online dispute resolution platform. And we have been recognized by APEC and the Ministry of Law in China as China's ODR service provider. That's a new attempt and innovation for us too. Second suggestion is to fully leverage technology so as to empower the smart transformation of a dispute resolution. In this way, of resolving disputes can become more inclusive, accessible, and interconnected, supported and empowered by the technology. It also helps to avoid abuse of technologies. We should also make efforts to avoid abusing technology so as to safeguard the justice and fairness of the proceedings and data security. We noticed that in recent years, there has been a number of research findings in this regard. For instance, the ICCA, International Commercial Arbitration Council, released a research finding on whether the parties to international arbitration have the right to online trial. IBA, International Bar Association, also formulated the guide to technical resources for arbitrators. And this year, the Arbitration and ADR Committee of the International Chamber of Commerce also released the report using technology to achieve fair, effective, and international arbitration procedures. We do notice that all these have also been included in the 2022 Global Arbitrators Declaration that was issued at the conference of the second global referees of SciTech in September this year. We believe that with those studies and researches, with the fully employment of technologies, this will help the international arbitration to embark on a new round of transformation that is of lower cost, better transparency, and higher efficiency. The third proposal is to fully leverage the network and internet technology and online dispute resolution to support domain name dispute resolution. According to the latest data of 2021 of ADNDRC, it takes by average 40 days to resolve and complete the procedure of a domain name dispute case. This has been attributed to this online procedure that is empowered by digital technology. If we look at the practice of domain name resolution, we believe that the domain name dispute resolution mechanism is a preferred way of resolving disputes that is fair, efficient, fast, and with enforcement in place, effective enforcement in place. We believe that in the future, in this digital economic era, the protection of online IPR should attract more attention and priority. The ODR mechanism of a domain name dispute is an important and integral part of this online protection mechanism of IPR. We, in mid this year, established the IPR Arbitration Center at SciTech so as to provide experienced, prestigious way and service of resolving IPR-related disputes. I believe that all these above-mentioned measures will also enable us to play a more vigorous role to protect IPR via online proceedings. Ladies and gentlemen, we are confident that in the digital era, dispute resolution of domain names will embrace a brighter future and has bigger role to play. On the occasion of the 20th anniversary of ADNDRC, we will continue to pursue innovation and work together with various stakeholders to better the domain name dispute resolution mechanism, to do more researches, tapping into the potential of online dispute resolution mechanism and play our due role. Lastly, I wish this conference a great success.
Thank you, Mr. Wang, for your opening speech. Now I would like to give the floor to Mary Wang, Vice President for Strategic Policy Management at Internet Corporation for Assigned Names and Numbers, ICANN. Over to you, Ms. Mary Wang.
Hello, everybody. I hope that you can hear me. Thank you for the kind introduction, Moderator Gu, and thank you very much for the opening speech, Vice Chairman Wang. I am Mary Wang from the Internet Corporation for Assigned Names and Numbers, or ICANN. It is my great pleasure, privilege, and honor to join you all today from Los Angeles in the United States. I am originally from Singapore, so it is extremely heartening to learn about all the innovations and all the advancements that SciTech and all the ADNDRC offices have been doing to further the cause of domain name dispute resolution services, and of course, to help protect the rights of intellectual property owners, domain name holders, and everyone involved in the online economy. I know that everyone here today is very familiar with ICANN. So I just want to use my time to speak on a few things that I hope are relevant to the conference today, with two very interesting topics and panels to follow this session. But first, please allow me, on behalf of ICANN, to congratulate ADNDRC on your 20th anniversary, and of course, all the offices of ADNDRC. The Uniform Domain Name Dispute Resolution Policy, or UDRP, is slightly over 20 years old, so only slightly older than ADNDRC, which has already done a lot in the 20 years of its existence. I just want to stop here to check that the sound is coming okay. Thank you. So congratulations on your 20th anniversary. Those of us at ICANN that work in this space look forward to many, many more years of collaboration with ADNDRC and all four of your offices, all your staff, your panelists, and everyone involved in domain name dispute resolution. So one of the things I'd like to highlight about ICANN is what we call the multi-stakeholder model. Under our bylaws, ICANN's mission is to ensure the secure and stable operation of the Internet's unique identifier systems. We do this in many ways. Our bylaws specify certain commitments and core values that we have to abide by. And this includes the coordination and the facilitation of many policies related to generic top-level domains and registrations in generic top-level domains through a bottom-up multi-stakeholder consensus-based process. I know this is familiar to everyone attending the conference, but we wanted to emphasize this today, particularly for this audience, because what this means is that ICANN as an organization, or the staff at ICANN, like myself, we do not make the policies. We did not develop the Uniform Domain Name Dispute Resolution Policy. That policy, which we call a consensus policy, like all the policies that ICANN manages, was developed by our stakeholders around the world, our global multi-stakeholder community. That includes everyone here at this conference today. That includes ADNDRC and all your offices, and everyone who is an expert in trademark law, in dispute resolution, in intellectual property, and in so many technical, legal, and operational parts that make the internet and the domain name system what it is today. The reason why I want to emphasize this, as some of you know, is that the UDRP is the oldest, the first consensus policy ever developed at ICANN by our global multi-stakeholder community. And our community has committed to reviewing the UDRP in the coming months and years. That effort has not yet launched. I think you will hear from my colleague Antonietta in the next panel about some of the preparation that we are doing for that upcoming review. It is very, very important that all of our stakeholders, whether you are an intellectual property lawyer or a dispute resolution provider or a domain name registrant, if you are familiar with the jurisprudence that has been built up in the 20+ years of the UDRP, that we hear from you, that we get your input, and that in particular, voices and representation from Asia are part of the process of review, reform, and improvement. So please look out for some news on when that effort will launch, because we really would love to have your feedback, your input, and your expertise be part of that review. The other thing that I did want to also highlight in these opening remarks before going into the conference proper is that in addition to the UDRP, as again, many of you know, in the last 10 years, other rights protections for trademark owners were developed by our stakeholders at ICANN. This includes rights protection mechanisms that were developed for the last expansion round of generic top-level domains, which started in 2012, 10 years ago. I think this audience will know that I'm speaking in particular about the Uniform Rapid Suspension Procedure, which was new at the time, which is built and modeled on the UDRP with some significant differences. For example, the remedies are different. Under the UDRP, as you all know, a successful complainant can get the domain name transferred or canceled. Under the Uniform Rapid Suspension Procedure, the only remedy is suspension. And another difference, as again, I think many of you know, is that the burden of proof under the two procedures are different. I highlight this new procedure for at least two reasons. One is that it does add to the number of online dispute resolution procedures that are available to intellectual property rights holders. So it becomes an additional strategy, tactic, or weapon as you protect your intellectual property rights in the online and digital economy. The second reason why I mentioned this new procedure, which, as I said, was modeled on the UDRP, is that this, along with other new rights protection mechanisms, underwent a review very recently by our global stakeholder community. So what you will see now that the review is done and the improvements that our community recommended have been adopted by our board is that there will be some changes to that particular procedure, the Uniform Rapid Suspension process. They are mostly procedural in nature, but changes are coming to that. So please watch out for those changes as they are announced. And in this regard, ICANN would like to thank the ADNDRC for your collaboration, for your cooperation in providing us with much of the data that we needed to complete that review. And we hope, as I said earlier, that as we go into a review of the oldest consensus policy developed by our global community, the UDRP, or the Uniform Domain Name Dispute Resolution Policy, that we will also see the same input, the same expertise, and the collaboration that we have enjoyed with the ADNDRC panelists and lawyers from Asia particularly. So I do look forward to an engagement. I know that many of you are familiar with our team who are on the ground in Asia. In particular, I have a colleague, I believe, who's present today, Zhang Jianchuan, who is present in China to engage with our stakeholders. So if you have any questions, if you have any suggestions on how ICANN can work with all of you to improve the world of online domain name dispute resolution, please do not hesitate to reach out to him, to me, to us. And with that, I will conclude my remarks. Wish you all a very successful conference, and we at ICANN look forward to the outputs of this conference, and hopefully this will be useful information for the next era of the UDRP and online dispute resolution. Thank you very much.
Thank you, Mary Wang, for your opening remark. I would also like to take this opportunity to thank ICANN for accredited ADNDRC as the resolution service provider. And also, I would like to thank ICANN for your support to ADNDRC's work. This year marks the 20 years of ADNDRC's foundation. So in order to memorize this historic moment, we have prepared a very short video. This is a short review of our 20 years history. So please enjoy the video.
当时成立这个中心，主要是为了满足因互联网经济迅速发展所带来的迫切的互联网纠纷解决需求，保护市场主体的知识产权和合法权益。
We thought about, should we have basically a sort of a group of individuals or entities in Asia who will actually group together and form what we call the Asian Domain Name Dispute Resolution Center, who will handle not just English type domain names, but other language type domain names that basically are more akin to this part of the region.
In light of the international nature of domain names, the most key advantage of ADR option for domain name dispute resolution lies in right here, that the decision can be readily enforced without regard to territorial borders.
The guideline we have just published aim to provide panelists a useful reference for drafting UDRP decision.
我认为数字经济的蓬勃发展离不开健康、稳定、安全的网络域名环境，国家也需要域名争议解决机构来提供高质量的域名争议解决服务，促进互联网络服务的创新，为数字经济发展的法治环境提供保障。
Thank you. That's the end of the opening ceremony. Now we'd like to get started with session 1, which focuses on retrospect and prospect of ADNDRC at its 20th anniversary. We are going to recap the practices of ADNDRC and its role in promoting UDRC development and look forward into its future. Firstly, I'd like to give the floor to Mr. Eric, Vice Secretary of Hong Kong International Arbitration Center, to moderate the session.
Many thanks to CTAC for inviting me to participate in this year's ADNDRC conference, particularly in respect of its 20th anniversary. It is a great honor to be here and to moderate this session, which is ADNDRC at 20, Retrospect and Prospect. 20 years of the ADNDRC, looking backwards towards the history and developments of the ADNDRC, and then looking forward prospectively for the next 20 years. We'll be hearing today from a panel of esteemed experts and ADNDRC council members who will be speaking in respect of the reforms that have already been made with the UDRP system and what they anticipate the next 20 years will bring forward. To begin, I would like to invite Christopher To to give a special report in respect of the DNDR mechanism under the UDRP and ADNDRC's practice. Chris is a ADNDRC council member. He is also a chartered arbitrator, certified adjudicator, and accredited mediator. He's a chartered engineer, chartered information technology professional, as well as a barrister at law and a law professor on the panels of various leading arbitral institutions. He has arbitrated, adjudicated, and mediated a variety of cases and represents clients in cases within the dispute resolution field. Mr. To is currently a barrister at Gilt Chambers and the program director of the LLM in arbitration and dispute resolution at City University. And he was previously the Secretary General of the HKIAC from 1998 to 2008. Chris, I'm going to pass it over to you for your special report. Thank you.
Thank you very much. Can you all hear me? Yes. Thank you very much, Eric, for that kind remarks. And also thank you, Mr. Wang, Ms. Wong from ICANN, and also Mr. Gu for actually doing the opening. I'm going to talk to you about, for example, a few areas. So I'm going to do it slowly. First one is about the history. Now, many people don't know about the history of ADNDRC. ADNDRC basically was a concept we had a meeting in Beijing with. And at the meeting in Beijing, we sat down with people from CTAC and we thought about internet. We thought about future disputes. We thought about how we're going to resolve disputes in terms of going forward. Will it be the conventional way of doing disputes or should we be focusing on the online dispute resolution? Then I decided to do some research. So I decided to do some research to find out, for example, what kind of disputes are resolved online. And I came up with the webpage of WIPO, World Intellectual Property Organization, talking about resolving domain name disputes. And I went deeper and tried to find out, for example, which organization was authorizing domain name disputes. And I realized that it was ICANN, the Internet Corporation for Sign Names and Numbers. And I managed to get hold of the people involved, and I flew to California, and I convinced them that basically we needed to have a kind of dispute resolution system in this part of Asia. And the purpose is because we have different languages, and we believe, for example, we need a platform whereby we can resolve disputes which more people are keen to in terms of the language issue. So I convinced them to decide, yes, we can create it. And one of the areas they told us that we must do is we must get more bodies from Asia to participate. I started off with CTAG, and we started off with Malaysia, and after Korea. So in a way, we've got 4 board members or 4 organizations from different regions now part of ADNDRC. In saying that, we are also looking for other entities around the Asia Pacific region to join us. So we're open to new ideas from other bodies who are interested in joining the Asian Domain Name Dispute Resolution Center. And I think this is a consortium whereby we have been very successful over the years. I'll give you some indications. When we started doing this in 2001, we had 2 domain names. As of 2021, last year, we had 225 domain names. In total, since 2021 to 2022, sorry, 2021 to 2021, 2001 to 2021, we've had a total of 2,858 domain names referred to us. And you can see that we're in a way small compared to the other providers. The other providers, as Mr. Wang mentioned earlier on, quite a few. They have been going on for some time. And when we started at the time, there was only 3 providers, ourselves, WIPO, and for example, National Arbitration Forum. There's another organization called e-Resolutions, but that organization decided, for example, it wanted to pull out. On top of that, there was another organization called CPR. They also pulled out as well. So in a way, there was always been 3 organizations that have taken the lead since 2001, but subsequent to that, other organizations in the world have joined ICANN and are now providing domain name dispute resolution services. Now, in terms of the number of cases basically referred to Asian Domain Name Dispute Resolution Center, the demographics tend to be, the claimants tend to be, quite a lot of them are from mainland China. And also the respondents tend to be from mainland China. You can see there's quite a lot. In terms of the claimants, the second largest tends to be from the United States. And from the respondents, the second largest tends to be from the United States. And the third is Hong Kong in terms of claimants. And the third is for the respondents is also Hong Kong. So you can see there's quite a lot of, for example, people within this region referring domain name disputes to ADNDRC. Now, ADNDRC does provide in total 5 related services. One area relates to the UDRP, so Uniform Domain Name Dispute Resolution Policy. The other one is called the Uniform Rapid Suspension System, as mentioned by Ms. Wong from ICANN. And also another one called the TMDDRP, called the Trademark Post Delegation Dispute Resolution Procedure, as well as the TDRP, called the Register Transfer Dispute Resolution Policy, as well as other CCTLDs, that means country code domain names, that we handle as well. So you can see that each region, like Malaysia, Korea, and also China and Hong Kong, we also handle our own CCTLDs. On top of that, we actually operate, for example, the ADNDRC. So the services that are pretty good in terms of efficiency. The secretariat is very efficient, very helpful. I've been doing cases through them, and I can tell you that they're very efficient in terms of delivery, in terms of the documentation, and so forth. So I urge you to try ADNDRC to see, for example, for yourself, whether this kind of service is what you want. Now, one thing I want to talk to you about is that's the history of it, services. In terms of marketing, over the years, we have done a lot in terms of marketing, and mostly through, for example, online means. But going forward, we know that, for example, we need to do other things as well. And one of the areas that we've been doing a lot recently is webinars. We're trying to do webinars to tell you about, for example, what ADNDRC does in terms of, for example, each office. And also, for example, the conference that we're anticipating to do as we did this year with through CTAG. So we've done, for example, internal leadership series. We've done, for example, webinars and so forth. So the way going forward, we're going to do a lot of marketing. Hopefully we need your support in terms of going forward. Now, on this note, I want to mention a few things. Let me stop there with this. I just want to mention a few things. Now, in order to refer a dispute to the UDRP, there are basically three criteria that you need to satisfy. One is the domain name is identical or confusingly similar to a trademark or service mark in which the complaint has rights. The second is you have no rights or legitimate interest in respect of the domain name. The third is your domain name has been registered and being used in bad faith. So if you look around the world, you see, for example, most people are talking about some issues relating to domain name disputes. So the first thing that people mostly talk about or they advise their clients about is, have you registered a domain name? Okay, is that domain name yours? Okay, that's the first thing you have to think about. The second thing you have to think about is, do you own a trademark or a registered trademark in any country that you can actually show? And is this domain name a generic domain name? That means GTDLD. If it is, then you can actually use the UDRP, which is a very fast and effective way of actually resolving the dispute relating to domain names. It's very economical as well. Another thing is, does your domain name include a well-known brand? Okay, so in a way, for example, if you do not have a trademark, at least it's well-known within the community. And can you, that's the most important thing, can you prove bad faith on the other party? If you can prove bad faith on the other party, the chances are then you have a strong case of winning. Now, the UDRP does have rules and policies that actually tell you how do you classify bad faith. Now, in terms of going forward, okay, one of the areas that we basically are faced with nowadays is what we call, one area that I just picked up is in Europe, we have this called the European Union Data Protection Regulation, GDPR, and this GDPR basically is affecting in terms of, for example, when you're doing domain names, in terms of identifying who are the respondents and their details and so forth. So you have to spend a lot of time going through this process of trying to identify who the respondent is, the correct details and so forth. If not, the chances are what will happen is the secretariats from ADNDRC will communicate with the registrar, try to find out the correct information, if so, and convey it back to you and tell you that you need to amend your complaint form accordingly. So this happens quite often because complainants basically do not have the right information because sometimes in Europe, we are bound by this general data protection regulations. Now going forward, if you look at the internet, the number of people registering domain names has increased over the last year or so. I'll give you an example. Since 2008, 6.9 million people have registered GTLDs, okay, like the top level domain names called .com, .org. So this is basically a significant increase year on year. Is you're talking about 5% increase year on year. So you talk about 16 million people registering domain names every year. In terms of the CCTLDs, this is not. This is basically increasing as well. The growth rate is basically 3.4%. So year-on-year basis, we're talking about 3.4% of people are registering domain names. The largest number of domain names around the world is .cn. They have currently 22.7 million domain names. So you can see that in terms of growing number of the domain names is increasing, and the Chinese market is increasing. Number of domain names in China has been registered. And I think this is to do with a few factors. One of the factors is because more people are now working from home, or working from the office, they tend to use technology. They want to use domain names to actually communicate or even have their own web pages and so forth, or even selling their services. And also this issue about, for example, Eric is very keen on is cryptocurrencies. Cryptocurrencies is an area that's growing. And I think that this is something that, for example, more and more people are going to go into this area. And the answer is we need a domain name. So people are registering domain names in the hope that in future, if we do online banking, if we do things online, at least they have their own identity so they can actually take things forward. Another thing that we're talking about is why is people now moving towards more registering more domain names? Is simply because people are now moving in the state whereby things are done online, even shopping. Number of people doing shopping through COVID has increased over the period. So you can see that in terms of the prospect of domain names increasing, as well as domain name disputes increasing, I can tell you it is going to happen. Okay? And we at the ADNDRC do have the resources, the commitment, and the competence to provide the services that you require. So on this note, Eric, I'll pass it back to you.
Thanks a lot, Chris. And that is a very promising report in respect of going forward. I'd like now to introduce the next person, a member of our panel. He is Professor Zhao Yun. Professor Zhao is Henry Cheng Professor in International Law and Head of Department of Law at the University of Hong Kong. He has a PhD from Erasmus University Rotterdam, an LLM from Leiden University in the Netherlands, an LLM and LLB from the China University of Political Science and Law. Professor Zhao is currently representative of Regional Office for Asia and Pacific of the Hague Conference on Private International Law, and also a standing council member of the Chinese Society of International Law, a council member of the Chinese Law Society, a council member of Zhuhai International Court of Arbitration, and chair professor at Xiamen University from 2020 through to 2023. He is listed as arbitrator in several international arbitration commissions and sits on the editorial teams of several academic journals, including the Hong Kong Law Journal, Journal of East Asian International Law, and he is the winner of the Dietrich Verschuer Award 2006 by the International Institute of Space Law in France, and the first winner of the ISA Dietrich Verschuer Prize in the Netherlands, the first winner of the SADA Prize by the Foundation of Development of International Law in Asia. He's published widely on various topics, including particularly dispute resolution and space law. But today he'll be talking specifically about developments in the ADNDRC and domain name dispute resolution. So Professor Zhao, I will turn it over to you.
Thank you, Chair. Let me share my PowerPoints. Thank you, Chair, for your very kind introduction. It is a great honor for me to speak on this very important event to commemorate the 20th anniversary of the establishment of the ADNDRC. I still remember when I was first appointed as ADNDRC panelist in 2006, when Dr. Christopher Toh was still the Secretary General of HKIAC at that time. And actually another panelist in this session today, Mr. Dennis Tai, was also at that time overseeing the domain name dispute resolution mechanism as ADNDRC. So it was really a great pleasure to be with them in the same panel today to share our views on the domain name dispute resolution mechanism, to reflect on what achievements that we have made and what can be further improved or what can be further done in the future. When I started doing my, well, I will probably move back more than 20 years ago. When I started doing my PhD in the Netherlands, in the Erasmus University during 1999 to 2000, the topic at the time was dispute resolution in electronic commerce. I had the chance to look into the domain name dispute resolution. When the ICANN was set up, one of the main tasks was to examine and develop a dispute resolution mechanism for domain name disputes. The WIPO was requested at the time to do a research to explore how to resolve the domain name dispute resolution disputes in an effective and efficient manner. Later on, the UDRP was introduced for formal implementation in 1999. I still recall that my second academic paper in the English language was published at that time, which was entitled "A Dispute Resolution for Cyber Squatting," was published in the Journal of World Intellectual Property in the year of 2000, which reveals the functioning of the mechanism in the first year of its implementation. After all these years, the UDRP has been proved to be a very effective and efficient dispute resolution mechanism for domain name disputes. I would also say that this is the most successful example of ODR in a broader sense. This self-enforcement mechanism has provided an excellent example for us to consider possible approach in furthering the development of ODR in the future. It is not possible for me to touch upon all aspects of the mechanism within the limited time today. I will pick up certain issues and share with you my experience in this dispute resolution process. The quality of the panelists is important to the success of a mechanism. The panelist has a wide range of discretionary power, but it is also very important to ensure that the parties are treated with equality and that each party is given a fair opportunity to present its case. In this regard, I must say I have been rather flexible in dealing with procedural issues and try to give the two parties the opportunities to present their case. But at the same time, the panelists should also ensure that the administrative proceeding takes place with due expedition. So fortunately, as an academic in the university, I have more flexibility in time management and can produce a decision largely within the time frame that were defined by the UDRP. Substantive issues, definitely, we will also need to look at very seriously as the panelists should determine the admissibility, relevance, materiality, and weight of the evidence. When it comes to the language of proceedings, the UDRP provides very clear rules regarding the use of the language. It is quite straightforward. But again, the panel has some discretionary power to decide which language to use. In general, we will follow the rules which has made it very clear regarding the language, which should be the language of the registration agreement. But the panelists will be able to look into various factors. For example, the language ability of the two parties, the environment and when the domain name was registered. So the panelists will have some discretion power to decide to use other language, but with sufficient justifications. How to win a case? Dr. Christopher Toll has already mentioned the three elements that we will need to satisfy, namely the identical or confusing similarity. The first element, I still remember in the ADNDRC seminar a few years ago, mentioned that this element is rather useful and very important. If you can satisfy the first element, largely speaking, you can win a case, but of course not all, which I will come back very soon later on. The second element, the duty burden lies with the registrant of the domain name. And the UDRP also provides the scenarios when the registrant can provide evidence or to prove it has the rights or legitimate interests. And finally, come to the bad faith. If we refer to the WIPO report in the first place, we know that the UDRP was designed in a way to resolve domain name bad faith registration. The UDRP provides scenarios when certain action will be considered to be bad faith, but this is a non-exhaustive list and should be supported by arguments and available evidence. So in some situations or most situations, we will be able to make inferences from relevant facts and circumstances, including the following factors, such as the nature of domain names, the chosen top-level domain name, the substance of the website, the timing of the circumstances of registration, etc. there are various situations when I have to make the decision regarding the know or should have known. So that is the actual or constructive knowledge. Of course, when it comes to the well-known marks, it's rather easy to define. But we also look at the willful blindness situation, the duty to search for and avoid trademark abusive registration, etc. So to justify that the registrant of the domain name knew or should have known the existence of the trademark or the complainant. There are also situations of passive holding. Very interestingly, when I first took over the cases during 2006 to 2008 or 9, I realized most bad faith situations fall within the scenarios that were encapsulated in the UDRP. But later on, we found out more and more cases has something to do with a passive holding. That means you do nothing, but there are situations when we believe there's a bad faith. So the passive holding will not prevent a finding of bad faith. We will need to take into account various factors to decide on the existence of a bad faith. When it comes to the retroactive bad faith registration, the rules are very clear. Normally, there's no bad faith, but there are situations the panelists will be able to decide the existence of a bad faith. For example, the domain name was registered shortly before or after the announcement of the merger of a company, or the respondent has inside knowledge, or the public can get the media information publicly. So there are various factors that the panelists will take into account in deciding on the existence of bad faith. Now, when we come to the reverse domain name hijacking, I did receive some cases when the respondent requested the panel to declare the existence of reverse domain name hijacking. My position is that I normally will be rather strict in deciding whether to declare the reverse domain name hijacking. So the onus, the duty of, is on the respondent to prove the complainant's bad faith. Mere lack of success is not sufficient for finding of a reverse domain name hijacking. Now, I noted that my time is almost up, so let me come to my last slide regarding the reform of UDRP. I still remember the articles that I published in 2000. I mentioned some concerns from some practitioners, some lawyers mentioning about the fairness of the mechanism, because at that time, the success rate for the complainant is quite high. That probably this mechanism is biased towards the complainant. But is that true or not? So there will have been some discussions. My view, of course, I think in the first stage, we can see all the decisions are justified for the complainant side. So this has nothing to do with the bias or not bias. We look into the factors, we look into the scenarios. That's the situation, but in general, I think the mechanism has been successful, and I believe this has won the market. And the scholars and practitioners believe this mechanism has been efficient and effective in a way. And when it comes to the bad faith in registration and or use, there are quite some discussion. I still remember some cases I have done a few years back. And which are we going to use and or? Yesterday, when I really prepare for the presentation today, I was thinking passive holding is of no use. So that probably something to look into when we look into future reform to clarify the element here. Another issue, losers pay. Now, at the moment, loser doesn't pay unless the response decides to choose to have 3 panelists instead of 1 as requested by the complainant. So whether the loser will pay in the future and appeal, whether that we should introduce an appeal system. My personal view, probably no, because we are trying to come up with a UDRP mechanism to be efficient and effective. The appeals might prolong the whole procedures. And longer deadline for response, now the respondent has 20 days to respond. So is that short or long enough? And finally, broad application and ODR, we have mentioned that the domain name dispute resolution was rather successful. Whether it can be broadened or expanded to other fields of dispute resolution, we will need to really seriously consider whether ODR can adopt the UDRP model. But of course, we know that UDRP was designed only for domain name disputes, which in a way was quite straightforward. But when it comes to general disputes, we might need to think about enforcement and other relevant factors. So with this, I conclude my presentation and pass floor back to the chair. Thank you.
Thank you, Professor Zhao. And thank you for a very illuminating presentation in respect of the UDRP process. Just as a reminder for those who are attending, if you have a question for any of the panelists, there is a Q&A function on the Zoom. Put your question in, and we will have some time at the end of the presentations to discuss any questions which the audience may have, and we may have some discussion on some of the topics which have arisen during the course of the presentations. I'd like to now pass the floor to our next panelist, Dennis Chai, who is President of Policy and Compliance at Dot Trademark TLD, and also an ADNDRC Council member. He is a seasoned executive and consultant in both the public and private sectors, and has served as a full-time senior executive in leading international arbitration institutions and a domain name registry in Hong Kong for over 18 years. He is also a member of the Hong Kong Institute of Arbitrators and member of the Internet Committee of the International Trademark Association, and he has been listed as a domain name panelist of ADNDRC and has concluded over 30 domain name cases as sole panelist, presiding panelist, and co-panelist. Dennis is also an active advocate for alternative dispute resolution and online dispute resolution, and regularly publishes articles on his practice areas and delivers presentations, lectures, and training courses on various occasions. He is a keen researcher in arbitration and ODR, and has also been admitted as a part-time PhD student to the City University of Hong Kong since September of 2021. Dennis, I will pass it over to you to discuss trends and new developments in domain name dispute resolution.
Okay, thank you, Eric. Let me share my screen. Okay, thank you, Eric, again for the kind introduction. And it's my great pleasure to speak in this very special and historical event for ADNDRC. And time flies, it has been 20 years for ADNDRC, which I have not yet think about that. Oh, this is a big event for ADNDRC. Indeed, many thanks to CTEC, our office, our Beijing office of ADNDRC for their excellent effort in organizing this excellent event, timely under the pandemic, and getting all together with friends and some new friends and old friends as well. So I'm also under pressure speaking after Christopher To and Professor Zhao Yun, because you all know that Christopher was my boss when I was in HKRAC, and Dr. Zhao Yun was my teacher, Christopher as well, when I was a part-time LLM student for arbitration and dispute resolution. That was in 2006 and 2007. So indeed, I'm very delighted to grow with ADNDRC and the Hong Kong office, the HKRAC, for over decades. But it's what I can help for this seminar, because I saw a lot of familiar names in the attendance list. There were very experienced panel friends and arbitrators such as Alan and Gary and a lot of friends in ICANN, Valerie. It's good to see you online. But for me, it's as Dr. Zhao has well covered the topic, what I can contribute is from another perspective, telling some inside story of ADNDRC and some of my observation for domain name dispute based on my experience, so that both can, all of you can know how ADNDRC has been developed and what ADNDRC can contribute better to build a safer and better internet for the world. So without further ado, I'll just start my slides about ADNDRC that has been covered by our chairperson, Mr. Wang Zhenjie. I'm not going to speak too much, and we have 4 offices. This is very special and covering that have a very good coverage of the Asian region. So that's our difference or our features compared to other UDRP service provider. We operate under the same set of rules, same panel, and we offer very standardized domain name dispute resolution, as Chris mentioned, not limited to UDRP, but a lot of that you can find from our website for other domain name dispute resolution services. So now here comes another question. For domain name, it has been a new thing, but some people treat it as an old thing. But since we have apps and a lot of social media, but who cares about domain name? But indeed, domain name is an infrastructure, but not many people or lay person know about the importance of domain name. But you know that this is a domain name statistic from MIPO in 2020. It shows that lots of major industry in our economy, they use domain name, they care about domain name very much, like the banking and retail, fashion, and biotechnology are the major domain name filers in our UDRP cases. And domain name versus trademark, when we talk about domain name, may think, domain name is not an important thing, but trademark is quite serious. But indeed, nowadays, domain name may function maybe more important than a trademark does. And of course, both should be in a complementary or the connection or relationship. If you have a domain name or you have a trademark, you better register your trademark as a domain name to get it protected in the internet. If you discover someone register your trademark as a domain name, you better to resolve the dispute to UDRP or other means. But UDRP has proved as the most effective, cost-effective, and time-efficient way to resolve domain name dispute. And here comes another report showing that domain name are still very critical in anti-online counterfeiting. This is a web page from the Europol. It shows that it has been taken, many domain name has been, over 30,000 domain name has been taken down for the sake of counterfeiting goods. So I am very happy to be involved as a committee member in ICANN Internet Committee, not ICANN, sorry, that's INTA, Internet Trademark Association Internet Committee. And this is a committee especially look into the domain name infringement or online counterfeiting issue. So just let you know that domain name is still very important in a lot of dimensions in our economy. So some of the observation in domain name dispute, in my experience as a panelist, I have some observation here, and then because you are very experienced experts, and you may have decided many cases as a panelist, and these are the experience based on my cases. And recently, I was given a case to decide. I found that the complainant has improving the first element. The complainant provided the panel the registration certificate of their trademark, and also provide a lot of proof of use of their trademark, including the registration of domain names and how they use the domain names. This is a case involving TVB. And indeed, so when asserting that the complainant has a legitimate right under the UDRP, the complainant nowadays may provide the proof of use for the domain name registration and use of the domain name, how that domain name has been recognized as an identifier for their service and goods online. So this is a new trend. In the past, complainant just provided trademark certificate, that's it. But nowadays, when asserting their rights, they much more tend to provide evidence of their use of their trademark, including domain name registration. This is one of my observations. And secondly, I also observed that some domain name complainant, they are often involved in parallel trademark litigation in court. And this is a case when I was a panelist, and when I deciding the case, I noticed this is a very serious fight between two big law firms and representing their clients. Of course, the foreign firm representing the US PayPal, and the local firm, it's a Guangzhou company, engaged a big firm in China as well in defending the registration of and use of the Sino PayPal.cn. And eventually I discovered there was in parallel trademark litigation in PRC court concerning the validity of the trademark registration in court. But this is a .cn case. We all know that it's under 3-year time bar, and the panel should decide within the time limit, or if the case has been dismissed, and that would be causing difficulty to the complainant in refiling the case to the HKIAC. So this is a case quite complicated. I won't expand too much, but just to let you know that domain name cases is nowadays getting could be in the past we all think that they all simple case, straightforward, 3 elements can be decided by hours. But nowadays I think some of the cases might not be that simple and could be complicated. The panel need to think of a lot of things and have to have a careful ruling in the domain name cases. This is a case which I understand that my decision was appealed to the PRC court, and eventually the court upheld my decision. And so it could be complicated, and that also shows that domain names are very important. Otherwise, parties will not spend so much money to engage lawyer to fight for one domain name. And other observation, and this is quite interesting. I recently learned that HKIAC was involved in the domain name cases when HKIAC spotted that HKIAC.org.cn was registered by a cyber squatter or maybe a disgruntled party. But anyway, HKIAC has successfully recovered this HKIAC.org.cn from WIPO, because WIPO is also a .cn service provider. And HKIAC could not file a case with itself and could not maybe conflict of interest in filing with CTEC. So that's why WIPO may be a better forum for HKIAC's case. So it is not the first case that domain name disputes involve dispute resolution center, like other arbitration center like AAA and ICDR and ICC, LCIA, SIAC. They all have been involved in domain name dispute. This is a case many years ago, but that shows that cyber squatters is anyway, including arbitration centers, competitor, maybe friends. Another observation is because the COVID-19 pandemic, it triggered the increase of domain name cases in 2002. And HKIAC statistics shows that there were 51% increase of the domain name cases compared to 2020. The reason behind is that the social restriction measure further increased the use of the internet. That triggers all infringement activity is also getting more online. And domain name is one of the key arena for trademark owners to fight for their legitimate rights. So this is a good sign for lawyers, a good sign for arbitration centers because they will get more cases, but not a good sign for brand owners. And Of course, the domain name dispute, another trend I observed that complainants can always become a successful party. In HKIC statistic in 2019, the complainant successful rate is about 97. Of course, it may be vary by case. We cannot truly it is high or not. We cannot comment, but in general, that shows that the cyber squatting or registration in bad faith is easily or can be easily happened online. So this is the system of domain name registration and the value of the existence of the domain name dispute resolution services. And another observation, because all of you may know that famous brands are always involved. If you are getting more, the more you are getting famous, the more likely your name has been taken, can be taken by a cyber squatter. It also can be, domain name dispute can arise repeatedly, because it could be endless. When you recover some domain name and somebody can make some changes to the name that you have just recovered and register a new name and trigger another new filings of UDRP or URS. So here's some example why big corporation was repeatedly engaged in domain name dispute, like Tencent or Alibaba. This is a big brand. If you search on HKIC's website domain name decision page, you can find they file a lot of cases. They recover domain name. That is good for the consumer. If you are leaving this disputed domain name linking to fake website, that will cause a lot of damages to the public at large, and also it's not a good brand strategy, because people may get injury or will have some damages by going to the fake website. So another observation, just want to share how to detect domain name dispute or infringing domain name registration. First of all, let you know here's some numbers that you may be interested in. Over the internet, there are more than 363 million registered domain names globally. And in terms of the extension of the domain name, there were more than 150 extensions. And every day there are new domain name registration of more than 200,000. So the internet is changing fast every day. Most of the new registration domain name may have infringed the rights of the existing brand owners. Here comes an example. This a famous celebrity, a name of a Beijing Winter Olympic champion winner, the Eileen Gu Eileen. And shortly after he won the Olympic gold medal, we discover, of course, we have a tool, a monitoring technique or a platform to discover that there are many of the new domain name have been registered concerning its personal individual name and the different top-level domain names. So here is an example showing that there are great potential for domain name disputes. If I'm a lawyer for Ms. Gu, and I will definitely investigate further and how to recover this name. Another new trend I have experienced or have been working with some friends and companies is there is a use of verifying domain name to avoid dispute. We always talk about domain name dispute resolution. UDRP is good, fast, cheap, cost effective, but have we think about how to avoid domain name dispute from happening at the very beginning? And it seems that we need some balance to or give a better choice to the consumer or to the brand. That is the verifying domain name. First, let me cite the ICANN survey. ICANN did a Nelson survey in 2016 or 2017. It reveals that 70% of the respondents favor some level of registration restriction for the top-level domain names. because nowadays domain name registration is free of charge, but not free of charge. It's first come, first served, and it's internet is free and open. This is the fundamental principle, and we cannot assume that the registrant of the domain name is a bad guy. Is they going to register the domain name in bad faith? That was and also in line with the innocent principle that without a judgment or decision, you cannot assume that this person has a problem. But for domain name, since it's free and open, some verifying top-level domain name, they just set up another game rules, telling people that you must have certain kind of identity or eligibility to register domain name, such as the dog bank and dog trademark in Chinese character. We set up a new set of rules for verifying the domain name registrant eligibility before allocating or designating the domain name, in order to guarantee or make sure that the domain name registrant has legitimate rights, just like putting the 3 elements of the UDRP at from the back door to the front door, and to verify the domain name registrant in order before allocating the domain name. This is to build trust online, and I believe that some will this kind of domain name will help making the internet safer, or offer a better choice or another alternative for brand owner and consumer to connect each other on the internet. So this is my observation on verifying domain name. And the last trend I have observed, that more Chinese domain name maybe expected to be involved in domain name dispute resolution proceeding. Like, for example, in HKIAC or ADNDRC's experience, we have handled quite a number of Chinese domain name in the second level or in the top level. We have these cases, Alibaba concerned their Chinese name on the internet, and the Chinese name Chinese has been promoted as key languages on the internet. I think that MIIT in China and a lot of industry association and Gentron may know, and that we are promoting the use of Chinese domain name. And of course, in the new from the governmental level, certain authorities in China are heavily promoting the use of Chinese domain name, like the MIIT. It has a document specifying that Chinese domain name is important, and we should all improve the environment of the use of Chinese domain name in China. So, but this is a proposal from a national committee member to use more domain, to use of the Chinese domain name. And here comes my summary. So I think domain name dispute still plays an important role, maybe more and more important, as cyber squatting is still heavy under the COVID-19 pandemic. So we expect that domain name cases is continue to increase. So this is one trend. So ADNDRC and with the 4 offices still need to play important role. We need to think about how to enhance the case role and enhance the awareness of the brand owner in terms of online brand protection. And domain name dispute or infringing domain name detection is also important. And why the case load is relatively lower in Asia than the European country or the United States, because simply because that a lot of Chinese brand owners, they don't know this domain name has been registered or being used in bad faith. We need a new technology to help the brand owners to discover this infringing registration timely. And a lot of monitoring service provider provide this kind of services. And in terms of education, brand owner may use verifying domain name, which is a much more secure domain name to help reduce the opportunity or chances to be getting involved in domain name dispute, or provide a better choice to the clients to avoid misrepresentation on the internet, to protect their brand better. So these are my summary from dispute resolution and dispute avoidance and dispute detection. I'm happy to stop here and wait for the comment, maybe question. Thank you very much. Let me pass the time back to Eric. Thank you, Eric.
Thank you, Dennis. We have one last panelist who we are going to hear from, and that is Zhong Hongbo, or Julia, who is Vice President in Li, Leuven IPR Agency, and also an ADNDRC panelist. Her areas of expertise include IPR laws, the anti-unfair competition law, and the civil and commercial law of the People's Republic of China. Ms. Zhong has a wealth of practical experience in law in areas such as trademark application and protection, arbitration and litigation, computer software registration, mechanisms to settle domain name disputes, brand strategy planning, protection of copyright, and others. She has worked on many IPR protection cases on behalf of a large number of multinational corporations and Fortune 500 companies. She is currently a panelist of ODRC under CTAC since 2010 and a panelist of ADNDRC since 2020. In addition, she is the national advisory expert for overseas intellectual property dispute settlement and the expert of the Advisory Committee on Intellectual Property Case Guiding Research under the Supreme People's Court in Beijing from 2015 to 2019. Julia, I believe you'll be talking about trademark rights in UDRP. So over to you.
Thank you, Eric. Good afternoon. Many thanks for the invitation. It's an honor for me to participate in this session and share personal insights here. The previous speakers have given a full picture of UDRP proceeding and its history and its developments. What I am going to talk is focused on some specific issues. Let me share my presentation. Okay, as we know, the UDRP proceeding is different from litigation, arbitration, and other dispute resolution proceedings. It's only to resolve dispute concerning abusive domain name registration and use. The panel should act very strictly in accordance with the policy. The jurisdiction of the panel is limited to provide a remedy for cancellation or transfer of the domain name. Being a panelist, I did involved in and examined a few top-level domain name dispute cases. I found that trademark is a very important factor in the dispute proceeding. Almost all of disputes are trademark related. So the topic of mine is trademark rights in UDRP. Let's first look at what the policy sees. The paragraph 4A provides 3 elements like the previous speakers mentioned. The first element consists of 2 parts, that is trademark right or the judgment on identity or confusing similarity. The second element is concerning the respondent's right and interest. The third element focuses on bad faith acts. Complainant must prove that each of 3 elements is present. As I mentioned previously, the panel have to act very strictly according to the policy, but the policy are not very specific here. So 2 trademark related issues arise before us. The first issue is about the first element. The basic requirement is described as complainant's trademark without an explanation on what kind of trademark satisfies such requirements. For example, If a trademark obtained it later than the domain name, is it possible to file a UDRP complaint based on it? That's the first one. The second one is about second element. That is about respondent's right. If the respondent proves its trademark right, the complainant fails to satisfy the second element. If this is the case, should the panel stop examining the raised part and let the proceeding end it here? So that's two issues. Let's go to the first issue. What kind of trademark right is sufficient for filing a UDRP complaint? How about a trademark rights acquired later than the domain name? How about a trademark right acquired in a jurisdiction different from the location of the complainant and respondent? How about a trademark right covering the goods or services different from the respondent's use or business scope? Let's look at some previous cases. The first case is a WIPO case decided in 2006. It's a known case involving a famous soccer player, Wayne Rooney. The domain name was registered in April 2002, and the complainant's trademark was registered in December 2002. That means the same year, but 8 months later. In that case, the panel held the opinion that registration of the domain name before a complainant acquires trademark right does not prevent a finding of identity or confusing similarity. That is to say, complainant's trademark, whatever acquired early or late, meet the requirement of trademark right stipulated in the first element in paragraph 4A. And the second case was decided in February 2015 in ADNDRC Hong Kong office. The domain name was registered in 2012 and the complainant's mark was registered in 2014, which is 2 years later. In that case, the panel holds the same opinion with that in the WIPO case. The panel holds that the fact that the complainant's mark registered later than the disputed domain name does not affect judgment on identity or confusing similarity. And the third case decided in 2015 as well, but in ADNDRC Beijing office. The disputed domain name was an English character paopao.com, registered in 2001, but complainant holds a Chinese character mark paopao with the identical pronunciation with the distinguished part of the domain name paopao. The complainant's trademark was registered in 2005. That is 4 years later than the dispute domain name. The panel also held the same opinion with that in the WIPO case and in the Hong Kong office case. It supports the viewpoint that a trademark right is sufficient to file a UDRP complaint, no matter whether it was acquired early or late. From the previous cases in different jurisdictions, we came to the conclusions as follows. First, the complainant owns a trademark, then it satisfies the threshold requirements of having a trademark rights. So a UDRP complaint can be filed based on that. Further, the UDRP makes no specific reference to trademark rights. That is to say, the date, the location, and the goods or services of complainant's trademark are irrelevant factors in these proceedings. That's an observation about the first issues. Now let's move to the second issues. This is related to the second elements provided by the policy. According to a literal interpretation, if the respondent has trademark right, it indicates that complainant failed to meet the requirements of the second elements. Thus, the proceeding should be ended. Should we do that? Let's pick up a case to study. This was a WIPO case decided in 2000. Both complainant and respondent hold trademark right McDonough, and complainant's mark was registered in 1979 in the US, and the defendant's mark was registered in 1998 in Tunisia, but the respondent is not located in Tunisia. The dispute name was registered on the same year with the defendant's trademark, that is 1998. From the flowchart, you can see that the defendant's mark was registered almost 10 years later than the complainant's trademark, but only a few days later than his domain name. In that case, the respondent admitted that his Tunisia registration was obtained merely to protect his interest in the domain name. So the panel opined that a trademark has not been sought or obtained for a legitimate or bona fide purpose, but merely in order to bolster a domain name registration. So the trademark can be disregarded. In that case, the panel said it would be a mistake to conclude that mere registration of a trademark creates a legitimate interest under the policy. So, from the previous case, we reached the conclusion as follows. The fact that a trademark have been applied for or obtained by a respondent is not an absolute bar to a complainant succeeding under the UDRP. In addition, WIPO Overview 2.0 further explained, respondent may rely on a valid trademark registration to show prior rights under the policy. Nevertheless, such rights should be recognized only if the overall circumstance in the case show that the registration was obtained in good faith for the purpose of making bona fide use of the mark. That is to say, the panel should combine the second element and the third element and take all these elements into consideration. These viewpoints were collected from lots of UDRP cases and have been applied into my practice. So that's all of my presentation. Thank you very much for listening, and thanks again for inviting me. Thank you.
Thank you very much, Julia. And given the current time constraints, unfortunately, I don't think we are going to have time for any questions with the panel. So I think that just leaves me to thank the current panel, Chris, Dennis, Professor Zhao, and Julia for taking part in this first session. We have identified, I think, in this session that there has been a lot of growth and experience in the ADNDRC system and in the UDRP system that ADNDRC has a wealth of experience on over the last 20 years, but that there are still points to address going forward for the next 20 years. And I think our next panel is going to then talk about what reforms we should be talking about. And it would be my pleasure now to introduce the moderator of that second panel, Ms. Priscilla John. Ms. John is a case counsel at the AIAC, where she manages a diverse caseload of international and domestic arbitration, adjudication, as well as mediation and domain name proceedings. Aside from daily case management work, Priscilla is also involved in various ADR-related projects at the AIAC, including the AIAC Arbitration Rules Revision and AIAC's annual ADR Week. Upon reading law and graduating with an LLB and honors degree from the University of Hull in the United Kingdom, Priscilla went on to complete her certificate in legal practice and was subsequently admitted as an advocate and solicitor in the High Court of Malaysia. Prior to joining AIAC, Priscilla practiced as a lawyer, where she had predominantly advised and acted as co-counsel in the areas pertaining to construction and engineering, international and domestic arbitration, as well as general litigation. Priscilla, it's my pleasure to introduce you and for you to introduce the next panel. Thank you.
Thank you so much for the very kind introduction, Mr. Eric. Hello, everyone. A very good morning, good evening, and a good afternoon, depending on where you're tuning in from. I hope everyone is keeping well and safe today. It truly is a pleasure for me to be here, albeit virtually, to moderate the session entitled Ongoing Reforms of the DNDR System, Why and How. Now, as you may already know, domain name disputes continue to gain prevalence due to a widespread of practice of cyber squatting and convenient shift in conducting commerce online resulted by the COVID-19 pandemic as well. And trade owners for sure across the world have becoming more increasingly vigilant in reinforcing their online presence in offering authentic content and sales to their clients throughout the internet. Now, together with me, I have Ms. Antonietta Mangiat-Koti, Mr. Hanlei Hu, and Ms. Yenan Ji, a very stellar panel, I would say, excellently put together by CTEC, to discuss on the strategic considerations and possible reform of the domain name dispute resolution, as well as the internet governance more broadly. Now, without further ado, please allow me to introduce our first speaker of the day, Ms. Antonietta. Antonietta joined ICANN in April in 2013 and currently serves as a policy research manager. As a member of the Global Domain Strategy team, her areas of responsibility include the implementation of policies, recommendations, right protection, and subject matter research, and guidance to the ICANN organization, board, and community. Antonietta is a graduate from the University of Southern California, where she achieved her MA in Public Diplomacy, and also achieved a BA in Political Science from the University of California, Los Angeles. But unfortunately, due to time difference, she is unable to join us today live, but she has kindly sent across a recording to us, and she will be presenting on the Uniform Domain Name Dispute Resolution Policy Status Report, as well as a little bit of comment from herself on the upcoming RPM implementation. If I could get the CTEC team to just play her video, that would be great.
Hi, everyone. My name is Antonietta Mangiat-Koti. I'm a policy research manager on the Global Domain Strategy team at ICANN. Unfortunately, I wasn't able to attend the session live today due to conflict, but I have prepared a presentation that will cover two efforts that are led by ICANN, which is the work on the Uniform Domain Name Dispute Resolution Policy Status Report, as well as the implementation of the Phase 1 recommendations from the policy development process on the review of all rights protection mechanisms in all generic top-level domain names. So on today's agenda, I will start off with some background information on the UDRP, as well as the implementation life cycles of GTLD policies, which I hope will help provide some context into the work that we're doing. And then I will jump into the items related to the UDRP policy status report and conclude with next steps, both on the review of the UDRP as part of the RPM Phase 2 PDP, as well as the implementation of the rights protection mechanisms PDP Phase 1 recommendations. So the UDRP is the oldest of the ICANN consensus policies. It was approved in 1999. It was developed through ICANN's multi-stakeholder model, which is a community-based consensus-driven approach to policymaking. The UDRP was created to provide a quick, efficient, and cost-effective way to facilitate trademark protection at the second level and the DNS through a mandatory online administrative proceeding that can proceed or obviate the need for a court case. The primary documents required for its operation are the policy itself and the rules for the UDRP. To date, 6 providers have been approved by ICANN to conduct proceedings, including ADNDRC. ICANN approves providers to administer UDRP complaints according to the requirements of the policy and rules. ICANN.org also enforces the UDRP through its accreditation contracts with ICANN accredited registrars who have agreed to abide by and implement the UDRP for those domains that are registered through their services. So here we have the framework for the implementation lifecycle of GTLD policies, and the work related to the status report, which I will discuss in the next few slides, is anchored in this framework, which describes the policy implementation process for the ICANN board adopted GNSO policy recommendation, according to these 5 phases that you see here. So during the first phase, ICANN prepares the board for their consideration of the policy recommendations that were developed by the Generic Name Supporting Organization, or GNSO, which is ICANN's policy development body for generic TLDs like .com, .org, as well as new GTLDs like .xyz and .club. So once the board approves the policy recommendation, ICANN begins implementation planning, followed by the actual work to implement the recommendations and develop the consensus policy language. And we do so in consultation with an implementation review team, which is a team made up of community volunteers who are also typically involved in the development of the policy recommendations. Then the final implementations are announced to the community. And you see in stage 4 there, the consensus policy goes to effect, meaning that ICANN compliance then begins its policy enforcement activities. The work related to the status report is anchored essentially in the last phase of this framework. So the last phase of the framework calls for a review of policies when there has been sufficient data and time to highlight the impact of the policy, and a policy status report should be provided to the GNSO Council with sufficient data and metrics to assess the impact of the policy. So the purpose of a policy status report is to provide an overview of a policy and to support the GNSO's assessment of the policy's effectiveness. So this report could serve as the basis for further review or revisions to policy recommendations. And to help with the GNSO's assessment, the policy status report includes things like information and history related to the policy, background on processes and procedures, recent and readily available data related to the policy, and key issues that have been raised, as well as any changes or recent trends that have been observed. So as background here, the GNSO Council in July of last year requested that ICANN prepare a policy status report for the Council to consider as part of its scoping exercise for the phase 2 of the PDP that will look at the UDRP, including to help them determine recommended next steps for this effort. So phase 1 of the PDP, just as background, and I will touch more on this later in the presentation, focused on a review of all rights protection mechanisms that were developed to mitigate potential risks and costs to trademark holders that could arise with the expansion of the GTLD namespace, which occurred in 2012, when hundreds of new top-level domains were introduced to the DNS. So prior to initiating phase 2 of this PDP, the Council is expected to do a review of its charter to make sure that the recharting process is more focused on specific issues and topics that could benefit from a comprehensive policy review of the UDRP. So in March of this year, the draft report on the UDRP was published for public comment. And then in July, this was revised and submitted to the Council. So the data and information in the report is organized in terms of the UDRP's overarching goals as we understand them to be, based on our review of UDRP-related documents, community feedback and discussions, which appear to be concerning the efficiency of the UDRP, the fairness of the system, and whether the UDRP effectively addresses abusive registrations of domain names. And so those are the three goals of the UDRP as we understand them to be. The policy status report includes relevant data, key issues that have been raised, differing viewpoints as they relate to each of these goals. However, the data in the report is not expected to answer these questions because that's part of the actual genesis assessment of the UDRP during phase 2 of their policy development process whenever that is launched. So the data that we had available to support with the policy status report included internal reports on UDRP related inquiries that we received, as well as UDRP data points that we collected from each UDRP provider's website. And we worked with each UDRP provider in terms of having them review the data that we had collected from the website to make sure that the numbers and data in the report were accurate and complete. So here we have some of the key findings from the UDRP policy status report, which looks at UDRP-related data for the years 2013, when the first UGTLD delegations occurred, through 2020. This observation period was determined by the availability of data that we had collected from the provider's website. So during this 2013-2020 observation period, there were almost 39,000 UDRP complaints across all providers, involving around 67,000 domain names. From January 2013 to December 2020, over 32,000 UDRP decisions were issued by panels. Our analysis of UDRP provider website data for the observation period also shows that complainant win rates ranged between 71 and 81%, with complainants succeeding in obtaining the disputed domain name in about 78% of cases on average. UDRP-related tickets received by ICANN also slightly went up between 2014 to 2019, and around 61% of inquiries that we received involved issues related to a trademark of, for instance, holder alleging cyber squatting or IP infringing domain name registrations. So as part of this, of our work and this report, we consulted with the community. We did a public comment period. In March of this year, we received a total of 44 comments from individuals and organizations. The input that we received was mixed. Some commentators favored certain aspects of the policy, while others were against those very same aspects. Some of the feedback we received also suggested areas for improvement in the UDRP that may be considered beneficial. However, there seemed to be just a disagreement as to what changes, if any, should be addressed in the phase 2 of the PDP with respect to the UDRP. So following this public comment period, we updated the policy status report to include the relevant information from public comments. The report and the public comments summary report were delivered to the GNSO Council in July of this year. As mentioned, this report is then to inform the GNSO Council's review of the PDP charter and the scope of phase 2. And so the council may take this report into consideration to determine next steps and also possible timing for launching phase 2 of the PDP to review the UDRP. In terms of the phase 1 of the PDP, which looked at which was completed in January 2021, and it looked at the RP rights protection mechanisms that were developed for the 2012 new GTLD program, which are the trademark post-delegation dispute resolution procedure, sunrise and claim services, which are offered through the Trademark Clearinghouse, and the uniform domain name, uniform rapid suspension dispute resolution procedure. So there were 35 recommendations that came out of this PDP, this phase 1 of the PDP, and the board adopted all of them and directed that ICANN implement them in consultation with an implementation review team as per the consensus policy framework. So a call for volunteers was published on ICANN.org on October 19th. this year, we are looking for volunteers to participate in the IRT to assist us in the implementation of the phase 1 recommendations. For the call for volunteers, there is no deadline to apply, and the IRT is open to anyone who wishes to join at any time. So with regard to the implementation of the recommendations for this effort, we're incorporating a phased approach. So we're implementing a more straightforward to implement recommendations first, and then recommendations with more that require significant time and complexity to be implemented sequentially. So they'll be implemented sequentially according to level of effort. So that the recommendations that require updates to existing procedural documents concerning the rights protection mechanisms, for instance, the URS rules or the URS procedure, those will be updated first. The documents will be updated in accordance with the phase 1 recommendations, and they will be shared with the implementation review team for review and input. So this effort is currently in the second phase of the consensus policy framework that I discussed earlier. However, it's expected to move into the third phase shortly, with implementation work expected to kick off during the second week of November. So this brings me to the end of this presentation. Thank you very much for your time and for the opportunity to share this presentation with you today. I hope you found it informative. And if anyone is interested in knowing more about these efforts, please feel free to check out the links included in the next slide. And thanks again. Thanks again.
Thank you very much for your excellent presentation, Antonietta. And without wasting any time, we shall now move to our second speaker for the day, Mr. Han-Lei Hu. Mr. Han-Lei Hu is currently serving as the Chief Network Security Officer of the China Internet Network Information Center. And he is in charge of network business operation and the operation guarantee work of technical systems of the CCTLD and new GLT as well. GLTD. He is also a guest professor in Computer Network Information Center of the Chinese Academy of Sciences. Mr. Hu has a master's degree in computer software and theory, is a senior engineer title with deep domain name system technical background, long fully responsible for CNNIC top-level domain name system global service platform and software system construction, development, operation, and maintenance work. And he has accumulated rich experience leading the construction of CNNIC Information of Security Management System, project meeting with both ISO 27001 and China National Standard GBT 22080. For the first time, realized registration, analysis, and query services of CCTLD. Mr. Hu is currently in charge of the management of business of CCTLD, development and maintenance of the global service platform for CCTLD, and the .cn domain name has maintained the top CCTLD position in the world for 5 consecutive years. Mr. Hu has established extensive contacts with domestic and foreign domain name communities in terms of technology and business, and has rich experience in international exchange. Now, today, Mr. Hu will be talking about the improvement and development of the .cn domain name dispute resolution mechanism. Without further ado, Mr. Hu, the stage is all yours.
Hello, everyone. Thank you very much for the invitation of ADNDRC for inviting me to this 20th anniversary of ADNDRC. And also, I would like to thank Syed Tech for providing this platform so that practitioners in this industry can have the opportunity to gather together and to discuss important topics. Domain name resolution, dispute resolution is a very important topic. So today in my discussion, I want to talk a little bit about CNNIC as a registry for CC TLD and GTLD's work. And also, I would like to talk a little bit about how we think about our future work in terms of perfecting our work. Now, I have 5 parts in my introduction here today. First, I want to talk a little bit about CNNIC scenic basic information, because some of us here are not know very much about CNIC. We are actually approved by the Minister of Information and Technology. This is a registry organization which was established in 1997. We have 25 years of history. This year marks the 25th anniversary of CNNIC. Also authorized by ICANN, we run and manage 2 top-level names, .cn, including .cn. So these new GTLD as .cn is one of the largest CCTLD. In the past 6 years, it has been the largest CCTLD domain name. And then up to this year, .cn has over 20 million domain names. And in the past few years, we also looked at the relevant policies to ensure that .cn can develop in a healthy way.
So the total number of .cn registered domain names at our organization is quite stable. It's about 20 million in total. Therefore, for us, when it comes to the development of Chinese domain names, CNNIC has long been a vanguard or a pioneer in China to promote the development of Chinese domain names. CNNIC is the first and earliest to do researches of the kind in China. It is also the first organization in China that is part of the internet domain name mechanism and system. So that's a brief introduction to CINIC. Now, when it comes to the dispute resolution mechanism at CINIC, there are 2 types. Firstly, .cn as a domain name is China's top-level domain name. Therefore, it entails a dedicated dispute resolution mechanism that is aligned to .cn as a China's top-level domain name. Second is the .com. This is subject to UDRP, Uniform Domain Name Dispute Resolution. So these are the 2 mechanisms for us to manage and administer the domain name dispute in our organization. Since 2000, when ICANN just launched UDRP for 1 year, we actually referred to UDRP and formulated our own method for Chinese domain name dispute resolution. This is a trial version as a pilot for the administration of Chinese domain names. And then in 2002, CINIC formulated and published the National Top-Level Domain Name Dispute Resolution CNDRP and the National Top-Level Domain Name Dispute Resolution Procedure Rules. It has been revised several times. which is mainly adapted to the development of domain names, to the change of its features, and to the new features of domain name disputes, as well as aligning that to some of the Chinese law and regulation. Currently, the latest version was amended and revised in 2019. So it's been 3 years since we started implementing this 2019 amendment and revision of this CNDRP. All in all, when we formulate and revise the CNDRP, we fully consider and refer to UDRP. At the same time, we also take into consideration features of a Chinese national domain name and its alignment with the Chinese legislature and regulations. So this is a path we have been seeking to the Chinese domain name and country top-level domain name dispute resolution that is specifically tailored to China. Now, when it comes to the .cn domain name dispute resolution policy, you see that we have this procedure rule which stipulates the principles and definitions of dispute resolution, submission and service of the documents, complaint defense or respondent, appointment of expert panel, trial, adjudication, services, and service and publication of adjudication and decision, fees, and other matters. So in this rule of procedure for dispute resolution of national top-level domain names, this offers a very important reference for the administration of Chinese domain name or .cn domain name disputes. Currently, there are 3 agencies or service providers for the CN domain name dispute resolution. The first is SciTech. This is the partnership that we have with SciTech since 2001. And the second service provider is Hong Kong International Arbitration Center. The Hong Kong IAC was authorized in 2002. So for more than 2 decades, these 2 agencies have been providing high quality services for the .cn domain name dispute resolution. It not only helps to resolve the disputes among the parties, but also promote the development of .cn domain names in China. Third agency that was authorized in 2019 was the WIPO AMC. So there are 3 agencies that have been authorized by CINIC to administer the CN domain name dispute. When it comes to the .cn domain name dispute resolution rules, I think it has the following 3 features. Feature number 1, scope of application. It is stipulated that if the registration period of the disputed domain name is over 3 years, then the domain name dispute resolution agency will not accept this case or complaint. Second feature is the applicable rights. In terms of application of rights, it is applicable to cases where the domain name or the service mark or trademark of the complaint enjoys civil rights and interests. It's the same or similar enough to cause confusion. That means this is wider in its application scope compared with UDRP. The third feature is on the definition or determination of bad faith. It's or, not and. So that means the complainant only needs to prove that the domain name is maliciously or is registered in bad faith or used in bad faith, rather than proving both in place. So I think these are the features of the .cm domain name dispute resolution rules. On the one hand, as I said earlier, we fully refer to UDRP, but we also take into consideration China's conditions so as to formulate the rules for .cn domain name disputes. It's a sort of a tailor-made version for .cn. Third part of my presentation will be on the development of .cn domain name dispute resolution in the recent years. In the recent decade, if you take a look at this histograph, it's been quite steady and stable in its total number of cases. It's about 100 to 150 every year. In 2015, in 2019, there was a spike in terms of the total number of the cases. But if you look at the total ownership or registered .cn domain names, it's at the level of 20 million. So it's about 100 to 150 cases out of 20 million registered .cn domain names. That means it's actually an illustration of high quality registration of .cn domain names. So it's not of big proportion, and we didn't see big fluctuations. So it's been quite stable in the recent years when it comes to the disputes of .cn domain names. Second graph showcases the litigation of domain name disputes. Again, in the year of 2020, there was a spike. But if you look at the total number of registered .cn domain names, 20 million, this is still of a small proportion. So I think that in recent years, especially in 2020, there was a lot of investment activities going on in 2018, 2019, and that resulted in the spike of the dispute litigation of .cn domain names in 2020. Now, I'd like to move on to talk about the advantages of .cn domain name dispute resolution mechanism. It does have its strengths. Firstly, it's been quite sound. Secondly, it is very much effective and aligned with China's condition. To be specific, the first strength is fairness, efficiency, and enforcement. So the mechanism is fair, efficient, fast, and its enforcement is very well guaranteed. Second is professional service is of high quality, very efficient and fast procedures. The average time is about 40 days for the trial or for the proceeding to be completed. In addition, the registrar automatically executes the decision, and there is a very high level of satisfaction among the parties. If you look at the cases of litigation after the ruling, very few of them actually went through the litigation procedure after ruling. Cost is also very effective, very competitive in terms of the cost, with very effective protection against cyber squatting or use or registration in bad faith. Now, what I'm going to move on to talk about is the future direction of its reform. So I think looking into the future, here are some of my personal proposals for future reform and development. Number one, we believe that for domain name dispute resolution, application of the scope of application should be expanded gradually. In other words, apart from trademark rights, I think we can gradually expand those rights to other civil rights and interests that are enjoyed by the complainant. Because with this expansion of the scope from trademark rights to other civil rights and interests, it can provide a better protection for the rights of the complainants, especially curbing and deterring malicious cyber squatting. Second is to further strengthen the publicity so as to arouse awareness among the users for domain name protection and domain name dispute resolution. We have heard about publicity of ADNDRC. We've been benefiting from such publicity. But again, if we look at the reality, some of the right owners fail to effectively protect their own rights with this mechanism. So in the future, apart from expanding its scope of application from trademark rights to other civil rights, we should also further arouse people's awareness, help them to understand better and more about this mechanism of right protection so that they know how to better protect their rights, how to curb and deter those cyber squatting and other use and registration in bad faith. This is my suggestion for future reform and change of this protection mechanism.
And secondly, to perfect our own mechanisms. So our mechanisms is already highly improved. However, because we are living in an internet era, and with the development of economy and the change of our work mode, more and more digital technologies are used. So a lot of disputes and a lot of affairs are resolved online. Therefore, for our domain name dispute resolution, we need to consider how we can better utilize the power of internet and also to use the online platform to accept the cases and also to resolve relevant issues. So there are a lot of attempts that can be made in this regard. We believe that by doing so, the domain name resolution, dispute resolution can be further improved in terms of quality and efficiency. So that would conclude my introduction today. And I think for all guests here today, if you have any, say, questions or suggestions concerning dispute resolution, please contact us. Let's keep in touch. And we welcome all suggestions and opinions to help us better the management of CCTLD. So that's all. Thank you very much.
Thank you so much for your presentation, Mr. Hu. Perhaps in the interest of time, we could save the question and answer towards the end of our session. Without further ado, let's move to the third panel of our day, Ms. Yanan Ji. Ms. Yanan is a senior researcher and Internet Governance Research at the Internet Governance Research Center, the China Academy of Information and Communications Technology. Today, she will be talking about the progress on domain name governance system and policies, which she will emphasize mainly about the ICANN governance system, GTLD registration data policies, new GTLD subsequent procedures, as well as the regulatory approaches in China. She will also be talking about the development status of the internet domain name industry, and her emphasis will be mainly on the size and landscape of the global and China's domain name registration market. Without further ado, Ms. Yanan, the stage is all yours.
Yeah, thank you, Priscilla, and I'll speak in Chinese.
Thank you very much for CTEC's invitation. I am with CAICT. My name is Ji Yanan. So I actually work as a consultant for ICANN. So hopefully with our expertise and international involvement, I want to also discuss with all the peers here today how to realize better domain name governance. Now, on behalf of my team, I want to talk about domain name governance, development status of international domain name industry, and to share with you some of our thoughts. First of all, with years of development, the internet domain name ecosystem has become more and more matured. So we have seen a lot of supporting ecosystems as well. And then ICANN is coordinating the overall unique identifier systems. So it's playing a very active role in domain name governance worldwide, especially in policy making and policy implementation. So in the past 6 years, we're seeing that ICANN's operation has been developing very smoothly, especially because of the pandemic. We are seeing that the role of ICANN and its organizations are playing a very active role, especially with the change of international landscape. We're seeing more and more countries is trying to avoid risks, and we're also seeing the downturn of global economy together with the new technologies such as encrypted currency and also data technology. So we are seeing that there are new changes and new challenges. And because of there are name conflicts and inappropriate use, there might be more disputes. In order to cope with the new situation, every year ICANN review its strategy and to clarify the focus for the coming 3 to 5 years so that they can better prepare for the resources. Now, in optimizing policy making and improving ICANN governance and efficiency, there are established mechanisms. So during the ODP that can help us to deal with very complex issues. So all this is going to determine the future ICANN policy. And it's also have a lot of participants. So in terms of ICANN's core policies, we can see there are a lot of different policies. The purpose is to ensure GTLD system is compliant with GDPR in European Union, and also it should also be compliant to respective countries' laws and regulations so that third party can get GTLD data if they need. And then in terms of policy making, we have finished 3-phase reports. Including EDPD phase 1 and also EDPD phase 2, as well as EDPD phase 2A, which is to distinguish legal and natural person GTLD registration data. Now, in phase 1, the policy implementation has almost finished, and we are also soliciting public opinions. And phase 2 just started. So the task in phase 2 is very complex. So that would means to the ODP indicates that more data needs to be collected by SSAD for policy feasibility. So after 1 or 2 years operation, we may be in a better position to tell whether the policies are effective or not. So currently, we are still conducting a lot of surveys and consultations. So another important policy is new GTLD subsequent procedures. So this is very important to promote and sustain competitive environment in the DNS marketplace. Therefore, the policy recommendation has already finished and has been submitted to the board by December 2022. And during this phase, ICANN has proposed a few ODP assumptions. Hopefully, this can help us better our subsequent procedures. So there are a lot of work needs to be done. First, the board needs to approve the sub-pro policy recommendations. Once approved, the implementation will start, including the new GTLD applicant guidebook update, and also base registry agreement update, and also to develop the new GTLD application system. For example, its operation mechanisms and cost and profit mechanisms, and how to address DNS abuse, review the effectiveness of rights protection mechanisms, and also facilitate dialogue on closed generics. Now, some of this work won't be the precondition for starting the second round of expansion, but it would affect the overall policy environment. So some people expected that it will be no early than the end of 2023. So this is about related policy processes. So two-phase review of all rights protection mechanisms in all GTLD policy development process. We have ICANN colleagues already introducing this part, so I'm going to save time for you. We can also take a look at the situation in China mainland. You can see that in the past few years, the situation in China is very stable. The government is dominating the management, and the industry is also being tried to be more self-disciplined. So we have regulators from the ministries and also from provincial level. So they are trying to establish the policy to ensure that all these information in registration is authentic, so that future law enforcement can be easier and we can easily crack down on cyber crimes. Now, next, I'd like to talk about the development of status of internet domain name industry. So I will just refer to them as a global market and China market. So overall, with the pandemic entering the third year, the global market size is affected, but the impact has been shrinking. By now, we are seeing the total TLD domain name registration has gone up by 2.7%. While CCTLD domain name registration is up by 0.2%, GTLD domain name registration is up by 4.2%, while new GTLD domain name registrations is up by 9%. And with the development of the market, we're seeing that the global market is also continue its integration. A lot is happened with GoDaddy, which has changed its name into Identity Digital. So we're reminding the speaker to update the slides. So just give us 1 second. Okay, now the problem is fixed. Let's carry on. So as we were saying, given the economic context, therefore, there are a lot of M&As going on in the market. A lot happened with GoDaddy and Donuts, etc., those leading companies. So some of these companies have already entered the blockchain sector. And then because of various reasons, the China domain name registration market has been dropping for 5 quarters consecutively. And now the growth has been back again. And by now, we have nearly 35 million domain name registrations, which still is down by 10.6%. .cm domain name registrations is down by 7.1%. However, the new GTLD domain name registration is up by 0.3%. However, we believe that with innovation-driven economic development and demand on growth, I believe there are new opportunities for the market to rebound. And in terms of geographical distributions of registries and registrars, now worldwide, there are over 3,300 registries and registrars. They are located in nearly 80 countries and territories, now of which the number of US remains top 1. And there are some emerging economies in the top 20 list. For example, the registrars in Singapore is catching a lot of attention. However, from Latin America, there are fewer entities there. So US is also in the leading position in terms of GTLD and new GTLD.
Emerging economies are making outstanding contributions to the total global market, especially in China. It is the second largest domain name registration market and will exert great impact in the future. So if you look at the specific domain names, then .com, .org, and ccTLD, and .com has 46.1% of the market share, and the top 10 TLDs accounted for 62.1%. GTLD market accounts for 87.7%. If you look at China's market share, .cn and .com add up together to 83.3% of the Chinese market. Let's make a comparison of the GTLD in global market and in China market. Some of the leading registrars in China are actually making themselves among the best in the international market as registrars. Now, I'm going to talk about Chinese domain name development. Of course, for Chinese domain name, Asia is still the main region to use Chinese domain names. It can help to promote the inclusiveness and diversification of the international market for domain names. Therefore, IDN development, including Chinese domain names, have been on the top agenda for Chinese market to further develop such Chinese domain names. We also need furthering the policy support, publicity, and tests, as well as support and guidance to the registrators and to the companies. So all these efforts have been in progress. In the 14th five-year plan of China, there has been some specific guidance on optimization of the development environment for Chinese domain names. So I believe that it entails concerted efforts for us to promote the Chinese domain names and its dispute resolution. To conclude, the adjustment of ICANN's governance mechanism will affect and is affecting the participation of all parties in relevant international policy making. For international engagement, I do hope that there could be more cooperation between ICANN and Chinese counterparts, such as ADNDRC, for furthering its cooperation in the future. For this new GTLD subsequent procedure, it will help to increase the activity of the domain name market, and blockchain-based alternative systems are developing rapidly. So name coalition and rights protection issues that may be introduced by them cannot be ignored. We should pay special attention to those new challenges to be brought up by the adoption of new technologies like blockchain. And also, I think COVID-19 do speed up the digital transformation, which imposes a new challenge for the protection of domain names. And Chinese domain names is enjoying very steady progress. And I believe that in the future, we also entail some legislation to protect Chinese domain names.
Thank you very much, Ms. G, for your excellent presentation. I understand that we are going slightly above the time. So with that in mind, I do not want to hold any of the panel as well as the audience in, further. So perhaps we could keep the question and answer towards the end of the session. So please allow me to introduce the speaker for our next session, which the moderator for our next session, which will be a session on online intellectual property protection in the digital economy. And this session will be moderated by Dr. Yang Fang. Dr. Yang is the director of the Intellectual Property Dispute Resolution Department of CTEC and the Secretary General of the CTEC Online Dispute Resolution Center. She is also the Secretary General of China International Investment Arbitration Forum and a council member of the Asian Domain Name Dispute Resolution Center. She is also a member of the Chinese Society of International Law, an association of the economy and trade across Taiwan Straits. Dr. Yang is a CTEC arbitrator and a mediator, as well as a member of the Chartered Institute of Arbitrators, CIR. Dr. Yang has nearly 20 years of working experience in arbitration. She has arbitrated as a sole arbitrator in various types of cases involving trade, investment, and other commercial disputes. She has administered as case manager nearly 200 international and domestic arbitration cases and has worked with arbitrators from different jurisdictions. She has also scrutinized over 100 jurisdictional rulings and more than 2,000 arbitral awards. She was the chief editor of the periodical Arbitration and Law and the drafter of the CTEC Construction Dispute Review Rules. She is also qualified to practice law in PRC as well as New York. She received a LLB and LLM degrees from China Foreign Affairs University in 2000 and 2003 respectively, and received a LLM degree from New York University School of Law in 2011. She received a law PhD degree from Tsinghua University of School of Law in 2020. Now, without further ado, Dr. Yang, the stage is all yours.
Thank you, Priscilla, for your kind introduction. Good afternoon, good evening, or good morning, dear speakers or friends online. Session 3 is focused on online intellectual property protection in the digital economy. As we have 3 Chinese speakers in this session, I would prefer to moderate this session in Chinese.
Dear experts, friends, join us online. Hello to you all. Session 3 focuses on online intellectual property protection in the digital economy. Given the fact that the speakers of the session are 3 Chinese speakers, so I will moderate the session in Chinese. As is mentioned by the opening speech, this online intellectual property protection is a bigger framework, and the protection of domain names is part of this intellectual property protection. In this digital economic era, online intellectual property protection is faced with new challenges and difficulties. So I think in session 3, we are going to have a high-level discussion on the online intellectual property protection status quo and future development orientation I am very pleased to have with us three speakers who are very prestigious and experienced in this area. The first speaker is Madam Yan Jun. Madam Yan Jun is the Deputy Chief Judge of the 3rd Comprehensive Trial Division of Beijing Internet Court. She also was engaged in the trials of many demo and representative cases. She's going to talk about the practices of online intellectual property protection at Beijing Internet Court. Please. Thank you for the kind introduction. Can you hear me? Can you see my screen? If yes, I will continue. Dear experts and scholars, colleagues, and guests, good afternoon. I'm going to talk about new challenges and response to the legal issues, especially online IPR protection in the digital era. So for our court, we are dedicated to the trials of cases in the internet era. And that's why we are called the Beijing Internet Court. While handling the litigations of those cases, we have the first spot to observe the new challenges and features of those cases in the internet era. So I'm going to summarize what we have observed to you. A little bit of Beijing Internet Court first. It was founded in the year of 2018. It actually centrally governs the first instance specific types of internet cases within the jurisdiction of Beijing. It has two obligations in particular. On the one hand, all those cases are handled online. So this is an online e-litigation procedure. It's quite innovative in China. So if you look at the cases that we have been handling, most of the cases are actually the online litigation procedure. So we acted as an innovator to do experiments, to do pilot of this e-litigation procedure. Secondly, if you look at those cases that we have been handling, an important part of that is the IPR cases. It accounts for 76.3% of all the cases that we've been received and handled. So that means that more and more of the IPR litigation cases are actually happening in the internet. The violation of the rights happened on the internet. The conduct or misconduct happened in the internet. So when it comes to the vehicle for such behavior to happen, it happened in the internet. Therefore, Beijing Internet Court, as a court that centrally governs the first instance of these specific types of internet cases, we had a very big caseload. So you see copyright violation cases received and trialed by us add up to more than 34,000 cases in a year. So very big workload. When we were trialing those cases, we found that with the development of the internet industry, those cases do demonstrate new features as follows. Feature number one. In recent years, development of internet demonstrated several features. Number one, with the development of Web 2.0, everybody becomes the creator and disseminator of the content. That means the threshold for creativity is lowered. That means this gives an environment for a lot of infringement of copyright. Secondly, with some of the new internet technologies to support new ways of dissemination, it actually gave birth to many new forms of dissemination, live streaming or short videos. There is also new business model. Many of the new business models have come into being. For instance, shared economy or live streaming and sales through live streaming and meta universe or digital collection and its auction online, big data and its adoption. All these technologies gave birth to new ways of creativity, new ways of dissemination of those works of results of creativity, new behavioral patterns supported and empowered by technologies, and new business models. So to summarize, it means that there are three types of new challenges: new results of creativity, new behavior patterns, and new business models. And all these resulted in some new cases. For instance, new results of creativity. In 2018, at Beijing Internet Court, we trialed a short video case, whether short video is infringing copyright. In the same year, we also trialed another case, focuses on whether the AI generated article can be deemed as a result of creativity and as a result infringing or violating somebody else's copyright. We also look at the new behaviors like Pandodo, which is a search engine of Baidu NetDisk resources, or graph movie, using graphs as an illustration to retell the stories of a movie. Or we do see dissemination modes that have been quite diversified. In the past, we have the server standards for dissemination determination. For determination whether this is a way of disseminating information that violates someone else's copyright. But right now, there has been new dissemination platform like live streaming platform or algorithm, the adoption of algorithm, whether someone should be held accountable for that behavior.
So we also dealt with Ali Cloud and WeChat mini programs. So what kind of responsibilities or accountabilities should be determined? And also another type is new business models. As I have mentioned earlier, say live streaming, there are lead live broadcasters and how they cooperate with the platforms. So how do we really determine the tort? And also share economy is a new business model in terms of right of work. How do we apply that in this new business models? Concepts like metaverse, NFT, digital collectibles. So these are all very new. So how do we determine the boundaries of the platform's responsibilities? So these are some of the new challenges generated by new technology and economic development. So all this has imposed new challenges for our work. Now, next, I would like to share with you some of the cases that we have dealt with. So we can share with you more details. This also indicates how we cope with new challenges. First of all, Douyin short video case. You may know that starting 2017 or 2018, people call that the meta year for short video. And that is the year when short video industry started to take off. From its emergence to a faster development, very soon, we noticed that a lot of cases relevant to this business model. In 2018, we accepted the first relevant case, whether a short video is considered works. And in this case, we are talking about a very short video, only over 10 seconds. So whether there is the copyright and whether the copyrights should be protected. And that is a very important discussion here. So the plaintiff is the copyright holder, while the defendant, however, without the plaintiff's consent, has moved the short video to its own platforms. So first thing we need to consider is whether this short video is works. So when creating a piece of work, there are some requirements to meet, because this short video is to compete in a context. And then in this video, the creator take the Wenchuan earthquake as a background, and using sign language, he actually depict the process of the disaster, how that takes place, and how the remedies and reconstruction started after the earthquake. So when we are trialing this case, we think that the creativity and the length of the video does not have an absolute connection. Although the video can be very short, but it has originality and express clear feelings, it can be deemed as a copyright and should be protected. Therefore, in this case, for the first time, we deemed that short video can have copyright. So this is a huge motivation for the creation of more and more short videos. In the past few years, we no longer hear questions like whether a short video owns copyright, whether it is really a piece of work. So more and more people are willing to join this industry and create good content. The second case was the first case on artificial intelligence, whether a piece of work created by artificial intelligence should be protected. Now, in this case, the plaintiff claims that he is the author of the content. In fact, he used a software for retrieval, and once entering some keywords, for example, a specific date, and in a certain place, there is a dispute. So once you can input those keywords, you can, the system can generate the whole case process. You can get a visualized analytical report. So the plaintiff believes that he owns copyrights for that. This seems to be very simple article. This doesn't sound very complicated, but because the generation of this article is special, the software user just type in a few keywords. So the whole report was generated by the software through the developers of the softwares, and by using and mining the big data, they generate this report automatically. So whether this is the copyright we should protect, this has aroused a lot of discussions among the academic communities and in the industry as well. So based on the stipulation and the scope of the stipulations, we believe that the plaintiff only key in the keywords and there's no originality here. However, the developer of the software didn't input their originality into this report. Therefore, we deem that this article shall not be protected by copyright. However, the relevant interest and benefits generated should be protected. So for AI-generated content and whether that should be protected. There are different rulings in different courts. I think the legal basis is different. We know that in Nanshan Court in Shenzhen, there is another case. The user of software and the developer of the software are the same. And in that case, the court believes that because the software is a tool, although the report was generated by the software, however, behind this report, in developing the software, in configuring the software, the user actually demonstrate expertise in data mining and data use. So in this whole process, the developer and the user of the software did demonstrate some originality. Therefore, in Nanshan Court, the software-generated content should be protected as copyright. Therefore, I think this shows that for AI and software-generated content are considered as copyright. I believe there are different opinions, and we are still exploring on this path. Now, secondly, also let's talk a bit about the transmission of these content. Because earlier, as we said, because of the fast development of the technology, there are new ways to transmit and to disseminate those content. And very often, we may say that everyone are the creator and everyone are the disseminator of those information. So, for example, this is a case in point. The dissemination and use of a certain content, and how do we define creation, secondary creation, and how do we determine whether an infringement has taken place. So in this case, the plaintiff is a TV series, and then the plaintiff, the defendant, is a software that can keep the screenshots of the TV series. There are over 300 screenshots from this TV series. And then this software can broadcast these screenshots automatically and have automated explanation. So you can go through the whole TV series within 3 or 30 seconds, 3 minutes. So the major argument here is the defendant has raised a few points. First, the use of the screenshots from the TV series is different from the original TV series, which is a video. And the defendant said they use only the pictures, and they also have added some explanations and narrations. There is a reasonable use. They only use over 300 screenshots. And so the citation from the original video is very, very limited. And also the dissemination of these pictures are not replacing the original TV series. Instead, it can help promote this TV series, which will help improve the right owner's benefits and income. So the court deemed that by providing screenshots, by providing pictures, although it's different from a video, however, these pictures are snapshots from the original video, the original TV series, which are original creation of the right owners. So in this case, there are relevance here. And then in terms of use, although from the number perspective, 300 pictures is not much. However, the defendant's claims for secondary creation was from the plaintiff's original content. At the same time, the citation has exceeded the boundary of necessity. This is not to comment on the TV series. Rather, it actually demonstrates the major storyline of this original TV series and can replace the original TV series. So we believe that this is an infringement in terms of the way it disseminates the message. And another case is people claim that they are innovating the technology. However, it's just infringement of existing rights. So Pandodo is a case of this kind. The plaintiff in this case was a copyright owner, and the defendant is Pandodo's operator. So the software can help search what's on Baidu online disk. For example, you can share a movie among users, a latest hot movie. You can find some search results. So as long as other users search or key in those keywords, a lot of links would be shown. And through this kind of dissemination, the movies will be disseminated more widely. Pandodo claims that this is only technology innovation, and this is to help facilitate the search for the users. However, in our opinion, we believe that Baidu Online Disk is mostly designed for the storage and backup of personal documents. In most cases, the users are not transmitting or forwarding these documents to the third party or other people. However, through Pandodo's technology, there is a huge possibility of right infringement. And even when they know that, they still develop this kind of technology. This is highly possible that the software will be used for infringement. Therefore, we deem that Pandodo's operator should shoulder legal responsibilities.
Last is on the new business models. As I said earlier, live streaming platform, whether this platform legal person should be held accountable if the live broadcaster violates someone else's copyright. Well, if this is the user's infringement, the platform will only be held accountable when it already know or should be knowing the user's behavior or violation. But if this is the live broadcaster themselves, we find that it's getting more complex because the fundamental feature or nature of the behavior change. Because for this live broadcaster, this is a behavior for commercial gains. For instance, by sharing a movie with the viewers, it has a more clear, much clearer purpose for commercial gains. In addition, this live streaming platform also has a share for the revenues or proceedings of those live broadcast anchors. So if you look at the specific sharing, they even get half of the proceedings coming from the tips from the viewers who watch this live streaming. I believe that with this sharing of the commercial gains with a much clearer purpose for commercial proceedings of the live broadcasters' behavior, I believe that accountability is there. The platform should be held accountable if the live broadcasters violates the copyrights of others. The next case is for Wolf Warrior as the plaintiff, and the defendant is a software called Man View. This case happened against the background of shared economy, when Chinese government vigorously encouraged the development of a shared economy. Now, this is for shared membership. For instance, according to the regulations of Youku, which is a video platform membership policies, it allows the member to share the rights or to log in with more devices, multiple devices. It could be up to 5 users at different times if one has a membership of the Youku platform. And then this software is expanding that sharing in the name of shared membership. Let's firstly take a look at the cost. For this particular case, in its decision, we believe that the plaintiff, not the defendant, is the direct actor who places the work on a server that is available to the public. And the defendant only provides the link to the work, which does not constitute a direct infringement of the plaintiff's right to spread the information on the internet. And at the same time, because there is no direct infringement, the defendant's behavior does not constitute aiding infringement. But it should be based on the premise of mutual benefit and win-win for all parties involved, and the boundary of not harming the legitimate rights and interests of others. Yet, in this Man video case, the defendant's so-called shared members' profit model is based on raking the plaintiff's legitimate business resources, taking advantage of the plaintiff's competitive advantages, and damaging the legitimate rights and interests of the plaintiff. So we believe that this does not conform to the principle of good faith and business ethics of the internet industry and constitutes unfair competition. Therefore, in this case, it is finally decided as an unfair competition of the defendant. Now, if we look at the e-copyright tracing and co-governance system, this is what we've been building. If you look at this mechanism, mediation can also be fully leveraged to resolve disputes of the kind. We also developed another platform, which is a blockchain e-certificate platform, so that the right owners will benefit from this platform in collecting and providing evidence. It helps to determine the evidence. This can be uploaded to the third-party evidence storage platform. So with blockchain technology, it helps to make sure that these evidence will not be tampered. Those uploaded evidence and data can be exchanged with our platform in real time with a verification supported by the hash value technology. This evidence will be easily and efficiently verified and handed over to the judge directly. So it links the users, the third-party application platform that is connected with our blockchain evidence platform, that speed up the time, the speed of trialing cases of the kind. Thank you. Thank you, Madam Yan. Thank you for sharing with us so many cases demonstrating vividly to us what could be the new challenges of trialing cases of copyright in the internet era. What would be the new features of those violation conduct, infringement conduct? Thank you very much for sharing with us your perspective. The next speaker is Professor Xue Hong from Beijing Normal University. Professor Xue is a well-known expert in IPR protection and e-commerce. He's also serving as the member of the expert panel of e-commerce in APAC and United Nations. She's also the expert of a domain name dispute resolution proceeding panel of WIPO and the expert of ADNDRC. She has a lot of experience acting as the arbitrator of SciTag and many other cases. She's going to talk about rejuvenation of ADR in the digital economy.
Oh, thank you. Thank you, Dr. Yang. I guess I sent my slides over. Shall I share my screen? Okay, I'm going to do that. Thank you very much. I'm very much willing to donate all my time to Judge Yan. That's what she talked about. It's extremely interesting, especially the cases. Well, okay. It seems there's a technical problem. I don't need the slides at all. It's been sent over to the interpreter. What I'm going to talk about is nothing interesting, as interesting as Justice Yan has talked about. Those cases are extremely interesting. We should really invite Justice Yan over to my university, because those cases she talked about is being repeatedly cited in my students' dissertations. So it seems that we really need this first-hand experience. Okay, what I'm going to share with you, hopefully as quickly as possible, because I have another working group meeting, is the rejuvenation of the ADR in digital economy. I thought since our topic of this session is on digital economy. And I want to begin with the wording ADR. So that's needed to be presented in English. In Chinese, we don't use this term. Okay, ADR is acronym for Alternative Dispute Resolution. It's been existing for thousands of years as alternative dispute resolution mechanism, as arbitration, mediation, consultation to resolve disputes, and has been proved as efficient, effective, and suitable to resolve cross-border disputes in the globalized proceeding. So I'm pretty sure that we all know the benefit of ADR. And as Justice Yang has mentioned, even the judicial system is trying to integrate within elements of ADR. But what I discovered in digital economy is that this ADR has been rejuvenated because of the technological advancement. At the early days of internet economy, we believe that this ADR has been evolved into ODR, as online dispute resolution. However, not merely moving the cases online cannot resolve all the disputes and cannot really benefit the technological advancement. What I'm suggesting is to introduce another perspective that's make the dispute resolution smart, so that to increase AI-assisted dispute resolution, there's a reinterpretation of A in ADR. The AI-assisted dispute resolution, the new ADR, will try to integrate the artificial intelligence technology all through the proceeding. Well, I'm very much impressed by the AI technologies already being deployed at the Beijing Internet Court, as Justice Yang has mentioned. Oh, well, they are very sophisticated online litigation platform. Plus the very cute Robert this, at the front gate. What is even more impressive is a blockchain, the evidence platform. that's extremely technical savvy. But that's the issue here. I understand that AI has already been used in case management and in some part for the evidence authentication process. But there is a judicial ethnic issue that we believe our case is really decided by a human being, by a very learned, experienced, and skillful experts, not only by algorithm, a coding, a machine. So that's a fundamental bottom line of social justice, people's last resort for legal remedy. So that's for judicial system. I guess that there will be always the last mile. This cannot be replaced with AI. Let's look at ADR. I think ADR will provide a good sandbox test for the full deployment of artificial intelligence, especially in this kind of a skilled environment to test whether everything can be handled through the artificial intelligence. Okay, let's move to my first perspective, how to reinterpret A. The first aspect is augmented scope of proceeding. What that means augmented is that we not see that in digital economy, those disputes are not only limited to the disputes between IPR and a trademark and domain names like UDRP we've been talking about all through the afternoon, but also evolving to the other areas of intellectual property protection, especially copyright disputes. Oh, I see the case, very interesting, about live streaming, the DouYu case. Okay, I understand the parties made tremendous efforts to fix and consolidated evidence and move it to a blockchain platform to be able to submit to the court to trial. But just think about this is live streaming. If it can be resolved within the digital platform through an ADR, it will be hugely efficient and effective. So that's exactly happening in the world. We know the Digital Single Market Directive on copyright from the EU have already introduced a mandatory appeal system on the digital platform. So when a measure has been taken against a content provider on the platform, this party can appeal to the platform against the decision by using the built-in mechanism on the platform. And that's a very good chance for AI to be used to resolve this problem. And so you see that the scope of application is really expanding. My second perspective about reinterpreted ADR is automated proceeding. I assume that in the future, the whole proceeding will be entirely automatic, so that our very skillful learned case manager will no longer be bothered by those uninteresting procedural issues. So that has been partially resolved. We see a very smart platform to receive, to accept, to confirm, to serve case submissions from both parties, and can manage the identity of the party and to verify the truthfulness. And also we see that this platform has become very smart to handle more complicated procedural issues like the adding additional party or consolidation of disputes. And what I'm suggesting here is maybe more controversial. That is, are we really have the confidence to use the AI to select and appoint the adjudicator or the experts to try the case? I know the current system is already very sophisticated, but I see with respect to the domain name disputes, for some designated service providers, they have almost 1,000 experts. However, there's only a handful of experts always appointed to handle the disputes. So we see the very clear concentration of caseload. The problem is that these people, they've already tried hundreds of cases. And of course, the case manager know them very well and can contact them. They can resolve the disputes very quickly. So that they got even more concentrated to these small slate of experts. So I'm thinking whether if we replace the human being with AI, whether the system will become more open-minded and more depend on the expertise and the areas of professions to decide a larger slate of experts. My third aspect, that is also the last one, is about whether we can have autonomous discovery. I know this will be challenged by many people. Autonomous discovery is something that's go right into the holy land of education. I know that many people feel very uncomfortable to introduce AI in discovery. To my 20 years experience as arbitrator and more than almost 25 years as a UDRP panelist, I feel that most of the time when handling a case, spend on facts checking and discovery, and also discovering of the source of law. So I'm thinking whether it's possible to replace this part of work with artificial intelligence. Well, even though we are not very comfortable, we can just open up our mind, just presume a scenario. Let's use UDRP as an example. In the UDRP, there's a couple of the key elements that's already highlighted by the previous expert. I'm not going to repeat that. Let's think about. For the domain name registration information, of course, it can be done by AI because it's all open information. We have very reliable, globalized WHOIS database. But for trademark registration information, it's not so much easy. We don't have a globalized trademark authority. But instead, fortunately, we have a trademark clearinghouse that partially resolved the problem. So that if these AI was very skillful in data mining and the cross-vetting, they can use to verify the trademark registration information. And some other key facts, such as the prior use, if contended in legitimate interest by the respondent, or the strong defense, there's no bad faith, like the patterns of conduct, that can all be checked as effects by these technology. Okay, I'm going to my last point that, notwithstanding what I said, I strongly believe that it is only the adjudicator, the appointed expert, that should make the final decision and using these technology only as tools. They should never dedicate our salient decision and exercise of justice. And let me repeat what Mr. Wang said in the beginning, that I do believe there will be a brilliant future for both ADR and the new ADR. Thank you very much.
Thank you very much.
Now I would like to give the floor to our third panelist from this session, Mr. Wang Wei. He's the president of Guangzhou Institute of Internet of Things. And he used to be involved in a lot of key projects, key academic research topics organized by the ministers. And he is also a director of the public service platforms for National IoT Network. And Professor Wang, Mr. Wang is going to talk about the domain business development and in a Web 3.0 era.
Okay, I'm sorry. I think my audio is open now. I'm sorry, I didn't prepare the English version of the slides because given that today it is communication between the Chinese community and the global community. And because the topic I'm going to give today is about the DNS and the digital assets in Web3, given that it is a very new challenge, a new trend of the DNS, I'm afraid I can't express myself precisely in English, because then I have to give the speech in Chinese. For that, I beg your forgiveness. 好，接下来我会用中文来讲我的 slide。
While using Mandarin, I think I can explain my ideas more clearly. So the topic is the digital assets and domain name in Web 3.0 era. So the moderator has already introduced my background. For the past decades, I've been involved in relevant research. I'm not going to repeat that. So with the era of Web 3.0, just to double check, am I audible? So with the new era of Web 3.0, I think digital assets has drawn a lot of attention, and it is leading the industry development and leading the industry governance. The digital economy's development is actually running ahead of our policy making. So digital asset is not a new word. We know that in Web 1.0 era, our domain name and IP address are the most successful digital assets. I do agree with the previous speaker's opinion when they all mentioned that a lot of the discussions around domain names and also the governance and compliance and arbitration, etc. So all this has become a very successful functional systems. However, this system didn't factor in Web 3.0, which is a new development. Maybe because 2.0 and 3.0 is a fast development. So because the technology is developing so fast, then the system or the regulation can hardly catch up. So we're seeing that in terms of the data assets, and because of the development of blockchain, we're seeing more and more data assets coming into our vision. So how do we really resolve the relevant issues and disputes that has to do with these new technologies? That's a question to consider. At the same time, we also need to see that in Web 3.0 era, which is lagging behind the development of blockchain, because the blockchain is anonymous and is scalable. So for each branch on the blockchain, there is its encrypted algorithms, which cannot be shared, and all the platforms are independent from each other. So the feature of these technology do have its unique characteristics. Therefore, it doesn't fit into the basic framework of the regulators' governance systems. So the majority of the world are still in the Web 1.0 era, and then gradually, slowly evolved to Web 2.0. So a lot of our governance framework is still reflecting the features of Web 1.0 era. Say there are licenses issued by the governance, you have to register, and then you need to have a backup. There are regulators, and this is what established a framework. And this framework doesn't fit, as I said, with Web 3.0 technology. Let me give you an example. The most popular word is NFT or digital collectibles. So there are a lot of different names, but whatever the name is, we can see that in China, in terms of the compliance of digital collectibles, there are no clear stipulations. So different platforms are trying to apply for various kinds of license. As long as you get one more license, it's always better, it seems. So in another word, for digital assets or digital collectibles, what exactly is its nature? What kind of digital object are we talking about? There's no definition for that. Is it information service? Is it ICP jurisdiction, or is it a cultural by nature, cultural work by nature? Or should it be under the jurisdiction of the PBOC or CSRC, etc.? So there are no clear definitions for the nature of digital collectibles. There are so many attributes, but what exactly is the key attributes? There's no common ground yet. So this is an example. This example means that for government and its compliance framework, which is still in the Web 1.0 era, we need to evolve to Web 2.0 and even 3.0. We need to have one-on-one communications and service providing, while in Web 3.0, we need more than just the existing framework. So there is a gap to cover. We need an intermediate in the center to help us match with, say, the person who owns the collectibles and also the regulators as well and service providers. So actually, there are already a lot of new attempts being made recently. There is a platform called .art. So for .art, a few years ago, the platform claims that they only work and serve gallery and artists. Therefore, they actually expanded the traditional domain names. They added a lot of attributes into the domain names and registration information. So all these pieces of art will have a unique website and a unique domain name. And they also want to move the information on blockchain. So a few days ago, they launched the protocol.art service. And through this service, they have made the existing art pieces into NFTs so that domain names and NFT are combined together. So the information has successfully been transformed.
So in this Web 2.0, it goes beyond the digital asset. It's being changed into a domain name. So I think such integration does have some advantages. Number one, it fully uses the advantage of technology. The domain name system is able to support all those different types of information that is visible, or even those TST document. And once it's being changed from a binary system into a TST format, it is capable to be supported by the domain name. Second, when it comes to the compliance and policy foundation, what is the basis for the policy and compliance of domain names? Number one, I believe that ever since the birth of internet, and ever since China started to deploy internet, I think in the past 2 decades, under the leadership of MIIT in China, there has been a comprehensive set of compliance mechanisms around domain names. Thirdly, the domain name ecosystem still needs to be further aligned with the ecosystem of the international community. For instance, with mutual recognition or registration system in China, all these special plan or special practice of China. Secondly, I think China is a country that is most widely opened to foreign businesses when it comes to the development of businesses in Web 3.0. So given the previous advantages of China with its comprehensive protection mechanism of domain names, with its policy support, with a comprehensive compliance mechanism established, I think it provides a very good foundation for China to further integrate Web 3.0 with domain names. Previously, domain name is more of a trademark, similar attribute. But now its attributes has brought it even closer to digital assets of different kinds. Now I'm going to introduce to you NIAT.cm. This is a service platform that was approved by ADNDRC of China in 2003. Previously, this platform mainly served the determination of property rights, unique identification of property rights of physical objects. But right now we've been transforming that to digital objects, so that we will be able to adapt to the Web 3.0 era. So we are vigorously attempting and innovating some of the new solutions, including solutions of domain names, of digital assets. So on the 30th of July this year, we made some attempts with the Chinese registrars so that we will be able to have domain names as a way of transforming digital assets. And after those digital assets have been transformed to domain names, it can be better managed through the way of custody management at those digital platforms. Last year, we also launched a new insurance business, which is a domain name insurance business, so that with better insurance protection, domain name protection can be better aligned with new digital assets, such as non-fungible token, NFT. But with such integration, probably there's a need to revise and amend the legislation or dispute resolution mechanism. This is something that we're very much willing to cooperate with various stakeholders. When it comes to the digital assets, if you look at its ecosystem, it has a different rationale and logic for the protection of digital assets. So in our perspective, we believe that we should leverage the current existing compliance mechanism and framework for the conventional digital assets and try to build upon that mechanism and expand it to new digital assets, so that we will be able to, on the one hand, inherit the current legacy of this current remedies, legal frameworks, and further expand it to new digital assets. Lastly, I'm going to talk about a new concept, which is the decentralized digital certificate. It fully leverages the digital technology, such as blockchain, public blockchain, to make it transparent. And it features very reasonable cost, so very competitive in terms of the cost. We can also fully leverage those new technologies like private key management smart contract as a way of protecting domain names when it is closely integrated with NFT and other new types of digital assets. All right, so that's some of the attempts we've been making and some of my insights to share with you. Thank you. Thank you very much, Mr. Wang. In the era of Web 3.0, how to better integrate digital assets protection and domain name protection is a very new topic. And I'm very much looking forward to some of the innovative practices in the future. Thank you once again, Mr. Wang. Development of digital economy cannot become a reality without the progress made in online protection of rights, whether it is the online IPR protection or dispute resolution mechanism of domain names, or ADR, alternative dispute resolution and its progress, or integration of new digital assets with domain name compliance framework. All these are the endeavors we must continue to liberate our minds, to embrace and new ideas and stay inclusive. That's the end of session 3. Thank you very much. Thank you once again. Now we are going to proceed to the closing ceremony session.
Now I will change to English. We have finished the discussions and we now move to the closing ceremony. I would like to invite Professor Dae-hee Lee, a professor at the School of Law of Korea University and an ADNDRC council member, to moderate the. Professor Lee, please.
Okay, now you can hear me. Now it's a turn for closing ceremony. My name is Dae Lee, and a moderator for this last ceremony session. The speaker for this last turn is Miss Sarah Grimmer. I will briefly introduce Sarah. She's an arbitrator member at 20 Essex. She has more than 20 years of experience in dispute resolution proceedings in the field of commercial law, investment treaty, and international law. She served as an arbitrator in many dispute resolution institutions, such as Hong Kong International Arbitration Center, Singapore International Arbitration Center, and International Chamber of Commerce. Currently, she is a DNDR panelist and the ADNDRC council member. Please welcome Sarah. Sarah, go ahead, please.
Thank you very much, Mr. Lee. Thank you very much. And good afternoon to all of the distinguished speakers and to my colleagues and friends and ladies and gentlemen on this conference. It's my great pleasure and privilege to give these closing remarks to what has been a fascinating conference, and I must congratulate CTAC, which is the Beijing office, as you know, of ADNDRC, for their excellent work in organizing today's ceremony. I think it's the perfect way to celebrate the 20th anniversary of ADNDRC, and it's my honor as an ADNDRC council member and also as the former Secretary General of the HKIAC, which is of course the Hong Kong office of the ADNDRC. And I must also compliment the high standards of interpretation that I have benefited from today. So thank you very much. So over the course of today's 3 panels, we have heard a lot of information and insights and observations from our astute speakers. It was really a rich afternoon. And I think I can perhaps summarize by dividing what we've heard into the past, the present, and the future. And I think it's very important when we are celebrating such a significant anniversary as the 20th to look back at the future, look back at the past, look back at the nascence of the centre and where it's come from. We've heard much about the history of the ADNDRC and how its work developed, both from some of the key people who were there at the very start and who were so important to the establishment of the centre, but also from representatives from some of the most important institutions in this field. And then in terms of the present, well, I think it's always useful to have a snapshot view through statistics, and we've heard those from the centre. And we know that they are very promising in terms of the amount of work, because last year there was a 51% increase in the number of cases compared to the year before. And I think that in many ways, that's not surprising. And we will see what the years ahead show. But what we are hearing and what we can take away from all of the speakers is that the online activity in Asia particularly in China, is so important and it's growing. And we've heard just in this last session some really fascinating insights from the Beijing Internet Court about all of the activity that they are seeing and how there are so many new avenues for potential IP infringement with the evolution of new technologies. So I think that it's no doubt that domain name dispute resolution is important and will be increasingly important, and therefore the role of the ADNDRC as a centralized institution for domain name dispute resolution within Asia is very important, but not forgetting that 39 jurisdictions are represented in the cases of ADNDRC. So while it is Asia focused, it does interlink with the rest of the world. Also thinking about now, I think, we've heard about some of the issues and trends that the panelists are coming up against, and the fact that there are more complexities, more legal complexities than, say, we have seen commonly with respect to the 3 elements of the UDRP test and the other policy tests with which we are most familiar. We're also seeing discussion around domain name avoidance as well as dispute resolution with, for example, the restricted registration of certain TLDs and ways to improve the situation for the famous brands who are running up against cyber squatting repeatedly, and how better the system can serve those companies. But also importantly, the really increased use of Chinese domain names, because I think that will only increase, and the need for better detection of cybersecurity and increased publicity around the recourse that is available to companies. And then I think looking ahead to the future, there is so much to think about when we focus in on domain name dispute resolution and the more traditional areas of it that we have been thinking about for some time. It was really useful to have the update from ICANN on the UDRP policy review that has been conducted, and to understand where we are at in the different phases and what's to come. I also thought it was very important to hear from CNNIC and also to hear their proposals or their ideas with respect to reform, including expanding the scope of protection rights for claimants beyond traditional trademark rights, but also around the need to increase awareness about legal recourse for domain name infringements. And then we also heard the fascinating research from CICT. And then moving more broadly from domain name dispute resolution, but looking at ways in which artificial intelligence can improve our traditional forms of decision making, and whether or not that can be folded into the traditional forms that we have, including tracing trademark registration and easing up on some of the case management systems that we have in place. And then, of course, the last panelist who really gave us a lot of food for thought and thinking about how this traditional system of dispute resolution can and inevitably must adapt to the realities of Web 3.0, because that is a direction we are all inevitably heading in. So I think, in conclusion, I think it's the importance of domain name dispute resolution is undeniable, and it will only increase, but perhaps in adaptive ways, building on what we've learned over the last 20 years, but perhaps bringing things back to the ADNDRC. I think that we can leave this session with a lot of optimism. I know as a council member with insight into the internal workings of the centre that things are working very well between the 4 offices. We have regular meetings every quarter. We have 3 specialised subcommittees that are very busy with different work streams. We have very effective sharing of data between the offices. And there's a lot of intellectual capacity and energy that goes into our work. And there have been concrete results. Recently, for example, in April this year, we held the ADNDRC Practice Development Workshop, which is aimed at panelists to look at current issues, complex issues, and best ways to approach procedural issues as well as substantive issues. So making sure that the decision-making standards remain high. And somewhat related, we also published the ADNDRC decision drafting guidelines this year, which are also a very important aid to panelists. So I can only leave you with that optimism and confirm the dedication of the centre, and thank you all for the input that you have to the centre's good work. Thank you very much.
Oh, thank you, Sarah. Now, actually, we are kind of late. We are about 30 minutes late than scheduled. So now we are going to turn the microphone to the organizer of this conference. All right? Thank you very much. Is there any organizer? Okay.
Thank you, Professor Lee. Thank you, everybody, for being with us, joining us with us today. And here, but our friendship will last forever. Thank you very much for your support. See you next time.